Would you like to make £150,000 a year in your first job? Newly qualified solicitors actually get this amount of money. But if you're a law student, you probably already know that to get there, you need to go through the SQE. There are 4 key chunks of knowledge that you need to conquer in order to pass this exam. I'm Dr. Yannis and I've been teaching undergraduate students just like you for the last 20 years. In this video, we're gonna see how courts and lawyers work. We're gonna deal with legal system, legal services, dispute resolution, and solicitor accounts. I am now gonna pass you on to my team. They will explain everything with a great set of slides.
Did you know it's illegal in England to handle a salmon in suspicious circumstances? It's in the Salmon Act 1986.
And yet, this bizarre little statute sits in the same legal system that deals with constitutional principles, human rights, and judicial review. Welcome to the English legal system, where the same set of rules that define parliamentary sovereignty also worry about your behaviour around seafood. This lecture introduces you to the legal system for the FLK of the SQE. Think of this as a guided walk through the moving parts of law in England and Wales. By the end, you should be able to navigate the courts, explain why yesterday's paces matter today, read and act with confidence, handle rules of statutory interpretation, understand how Welsh and Westminster legislation coexist, and place constitutional principles, judicial review and human rights in their proper homes. We will also set the place of EU law in the UK Constitution post-Brexit. Dr. Yannis covers all the knowledge content the SRA determines is expected of a newly qualified solicitor.
The courts, the judiciary, court hierarchy, appeals, and rights of audience. Let's begin with the architecture of the English court system, the framework that keeps justice organised and decisions consistent across the country. At the foundation of criminal justice are the magistrates' courts. They deal with the smaller, summary offences, things like minor assaults or motoring cases, and they're also where almost every criminal case begins, no matter how serious it eventually turns out to be. Some offences, called either-way offences, can stay in the magistrates' court or move up, depending on how serious the facts are. The truly serious ones, the indictable-only offences, automatically go to the Crown Court, where a judge presides and, in most cases, a jury delivers the verdict. The Crown Court doesn't just try major criminal cases, it also handles sentencing and hears appeals from decisions made by magistrates. In civil justice, the starting point is usually the county court. That's where most private disputes begin, the sort of cases you might see about contracts, negligence, or property. But the bigger, more complex disputes, the ones needing specialist judges or involving points of law of wider importance, are heard in the High Court. The High Court has 3 historic divisions, each with its own character and expertise. The King's Bench Division hears contractual and tort claims, as well as applications for judicial review, the key mechanism for challenging public decisions. The Chancery Division looks after equity and trusts, company law and insolvency matters. The Family Division handles complex family disputes, guardianship and matters of wardship. Above the High Court sits the Court of Appeal, divided into a civil and a criminal division. Each deals with appeals from below, the civil division reviewing judgments from the High Court and County Court, and the criminal division hearing appeals from the Crown Court. Then at the very top of this judicial pyramid stands the Supreme Court, the final court of appeal for the United Kingdom in most matters. Created by the Constitutional Reform Act 2005 and operating since 2009, it replaced the Appellate Committee of the House of Lords, separating the highest judicial authority from the legislature to reinforce the independence of the judiciary. Running in parallel with the courts is the tribunal system, designed to handle specialist areas such as immigration, tax, social security, and regulatory disputes. It has its own structure, with the first-tier tribunal hearing cases initially and the upper tribunal handling appeals. From the upper tribunal, further appeals can go to the Court of Appeal, but only on points of law. And for certain rare matters, such as appeals from some Commonwealth countries or ecclesiastical courts, there's the Judicial Committee of the Privy Council, a vestige of the legal empire that still plays a role in specific jurisdictions.
Now, who are the people behind this structure, the ones who make the law work day to day? The judiciary.
Judges in England and Wales are appointed on merit through the Judicial Appointments Commission, ensuring independence and fairness in the selection process. Once appointed, their independence is protected by security of tenure. They can't simply be dismissed because someone dislikes their decisions. Removal requires serious misconduct and even then the approval of Parliament. This safeguard means judges can focus on applying the law without political interference. Modern judges are also expected to reflect the society they serve, impartial, diverse and transparent in their reasoning while remaining insulated from external pressures. Judicial independence is not just an ideal, it's the foundation that maintains popular confidence in justice. Rights of audience, meaning who can speak in which court, are structured around this system. Traditionally, barristers appear in the higher courts, presenting arguments before judges and juries, while solicitors handle client work, preparation and advocacy in the lower courts. However, the line between them is less rigid today. Solicitor advocates can gain extended rights of audience, and chartered legal executives or other authorised professionals may appear where their regulator permits. Still, the old distinction continues to influence how legal work is divided, how cases are prepared, and the ethical responsibilities that follow. Finally, let's look at appeals, the safety net of the justice system. Every case should have a route for correction, but appeals are not there to start everything over again. They're supervisory, designed to ensure that the law was correctly applied and that the process was fair. Appeals from the Magistrates' Court can go to the Crown Court for a full rehearing or to the High Court by way of case stated, that is, on a legal question. Appeals from the County Court or the High Court go to the Court of Appeal, usually on points of law or on mixed questions of fact and law, and only with permission. From there, cases may reach the Supreme Court, but only where a matter raises an issue of general public importance. At every stage, permission filters and standards of review act as checks. They preserve judicial hierarchy and prevent endless relitigation. The system's design ensures that justice remains both accessible and final, offering correction when necessary, but always mindful that the law must move forward, not in circles.
Development of case law and the doctrine of precedent. Now let's talk about the glue that holds the common law together, precedent. The English legal system is built on a principle known as stare decisis, which literally means to stand by things decided. What this means in practice is that lower courts must follow the legal principles, the ratio descendiendi, laid down by higher courts when the facts of the case are materially similar. These are the binding parts of a judgment, the core principles that must be applied again in future cases. Other remarks a judge might make, known as obiter dicta, can be persuasive and influential, but they don't have binding force. At the top of the pyramid, the Supreme Court has the power to depart from its own previous decisions when it is right to do so. This reflects a careful balance. The law must remain stable and predictable, but it must not become fossilized. The Court of Appeals, on the other hand, is generally bound by its own past decisions, that there are narrow exceptions. It can depart from its own authority to avoid internal contradictions, or where a higher court, like the Supreme Court, has changed the legal landscape. The High Court binds the lower courts, such as the county courts and magistrates, but not itself, and specialist tribunals are bound by higher judicial authority within their own jurisdictional area. Of course, the genius of the common law is that it can evolve while still respecting precedent. Courts create space to adapt through a process called distinguishing. This allows a judge to say that an earlier decision doesn't quite fit the case in front of them, because the facts, the context, or the legal framework are different in some meaningful way. It's a subtle craft, using similarity and difference to keep the law both coherent and responsive. And when a point of law truly needs to be revisited, the Supreme Court can overrule previous authority altogether. The real discipline for judges lies in maintaining the balance between respecting settled expectations and keeping the law in tune with modern statutory frameworks, human rights standards, and the realities of contemporary life. For practitioners, reading a case means doing several things at once: identifying the ratio, spotting the obiter, understanding which level of court made the decision, and then asking the crucial question, can my case be fitted within that line of authority, or can I legitimately distinguish it? That analytical habit is at the heart of legal reasoning in a common law system.
Primary legislation, the structure of an Act of Parliament and an Act of Senedd Cymru. Now let's turn to the spine of the legal system, primary legislation. An Act of Parliament is where law takes its most formal, written form. Each act follows a familiar architecture.
It opens with a long title, a short title, and an enacting formula that declares Parliament's authority. Then come the sections, which contain the operative rules, and the schedules, which expand the detail. Many acts include interpretation sections that define key terms, commencement provisions that tell us when different parts come into force, and extent clauses that explain where the law applies across the United Kingdom's jurisdictions. Alongside most acts, Parliament publishes explanatory notes. These don't have legal force, they don't change the meaning of the statute, but they're invaluable guides to the background, context, and legislative purpose. They show what Parliament was trying to achieve.
Now, in Wales, legislation is made by the Senedd Cymru, and its acts, known as Acts of the Senedd, follow a similar pattern but with a different constitutional foundation. The Senedd can only legislate within its devolved competence, that is, on subjects that have been transferred from Westminster under the devolution settlement. So, while the structure of an Act of the Senedd looks familiar, the scope of its powers is defined by the constitutional framework that underpins devolution. One special feature of Welsh legislation is that it is bilingual. Every act is enacted in both Welsh and English, and both versions are equally authoritative. That means courts must read both texts together where any ambiguity arises, interpreting them in a way that preserves consistency with legislative purpose and constitutional competence. In practice, this creates a fascinating layer of interpretation. The law literally speaks two languages, and both must be heard in harmony.
Statutory interpretation, literal golden mischief, purposive, presumptions and aids, including Welsh legislation. And that brings us to one of the most intellectually rich parts of legal practice, statutory interpretation, the art of making sense of what Parliament actually meant. When text meets fact, interpretation begins. The literal rule asks, what do the words mean in their ordinary, everyday sense? Courts start there because Parliament is presumed to say what it means, but the Golden Rule allows judges to depart from that plain meaning if following it would produce an absurd or inconsistent result, something Parliament clearly could not have intended. Then we have the Mischief Rule, which comes from a famous 16th century case called Hayden's case. Under this approach, the court looks back to the state of the law before the statute was passed and asks what mischief or problem was Parliament trying to remedy. The statute is then read in a way that suppresses that mischief and advances the remedy. Today, the dominant approach is the purposive approach, which asks what the statute was trying to achieve in its broader context. This is especially important in public law and human rights cases, where Section 3 of the Human Rights Act 1998 requires courts, so far as possible, to interpret legislation in a way that's compatible with convention rights. It's a vivid example of how interpretation and constitutional principle intertwine. Judges also use presumptions, default rules of interpretation, to guide them. They presume that Parliament does not intend to interfere with fundamental rights without clear and explicit words. Penal provisions are not stretched by implication. There is a presumption against retroactive effect, against ousting the jurisdiction of the courts, and in favour of compliance with international obligations. To uncover meaning, courts turn to aids to interpretation. Internal aids are those found within the statute itself, the long and short titles, section headings, punctuation, and the interpretation section. External aids are sources outside the statute, pre-legislative materials like white papers, law commission reports, and explanatory notes. And in limited cases, following the rule in Pepper v. Hart, judges may refer to statements made by ministers during parliamentary debates, but only to resolve genuine ambiguities or absurdities. For Welsh legislation, interpretation follows the Legislation Wales Act 2019, which sets out its own interpretive code. Because the text is bilingual, courts engage in what's called cross-reading, comparing both language versions to find the most coherent and faithful meaning. This bilingual dimension makes Welsh law a fascinating case study in how language shapes legal understanding.
The application of legislation made by Senedd Cymru and Westminster to England and to Wales. England and Wales operate within a single legal jurisdiction, one system of courts, one body of judges, one set of procedural rules. Yet devolution means that the substance of the law can now differ on either side of the border. What this means in practice is that two Acts of Parliament might sit side by side, one from Westminster and another from the Senedd Cymru in Cardiff Bay, each governing the same broad area but within its own sphere of authority. Most Acts of Parliament still extend to both England and Wales, but the detail often varies. Some provisions come into force at different times in Wales or contain specific carve-outs for devolved matters, areas where legislative power has been transferred to the Senedd. By contrast, Acts of the Senedd usually apply to Wales alone, though they can sometimes reach across the border where necessary. If, for instance, a Welsh law affects a cross-border public service, say health, education or environmental regulation, it may have limited effect in England, provided that the topic falls within the Senedd's legislative competence. So, how do you know which law applies? The practical skill lies in checking the extent clause of the statute. That section tells you where in the UK the law operates. Then you consult the Government of Wales Act 2006 as amended by the Wales Act 2017, which sets out the framework for devolution. There you'll find the key division between what's reserved to Westminster, such as foreign affairs, defence or criminal law, and what's devolved to Wales, including health, education, housing and the environment. Within those devolved fields, Welsh ministers can make secondary legislation to give detailed effect to Senedd policies, statutory instruments that implement, adapt and update the law as needed. This layered structure means that two lawyers, one in Cardiff and one in London, might handle the same legal question under subtly different rules. For practitioners, the habit of mind is constant vigilance. Always ask which enactment applies, on what date, in which place, to which person or activity. These may sound like small details, but in a devolved system, they can change the entire outcome of the case.
Parliament, parliamentary sovereignty and the core institutions of the state. Let's now turn to constitutional law, the framework that defines how power is made, shared and kept in check within the United Kingdom. At its heart lies Parliament, the supreme lawmaking body. The orthodox doctrine of parliamentary sovereignty tells us that Parliament can make or unmake any law it chooses, and that no court, government or other institution can override or set aside an Act of Parliament. That's the classic formulation. Elegant, absolute and uniquely British. But in practice, sovereignty today lives in a more complicated world. It coexists with other powerful constitutional forces, the rule of law, devolution, the Human Rights Act 1998, and, since Brexit, the ongoing status of retained and assimilated EU law. Sovereignty remains the cornerstone, but it stands within a network of constitutional relationships that constantly shape and restrain how it operates. When we talk about Parliament, we mean the combined authority of the House of Commons, the House of Lords and the monarch. Together they enact primary legislation, giving effect to the collective will of the state. In practice, the government, meaning the Prime Minister and Cabinet, controls most of the legislative timetable, introducing the majority of bills and steering them through the process. But it is Parliament that debates, amends and ultimately grants legitimacy through enactment. This process of scrutiny is more than formality. It's the mechanism through which democratic accountability meets the rule of law. At the centre of the constitutional machine sits central government, accountable in several directions at once. Ministers are answerable to Parliament through ministerial responsibility. They must explain and justify their actions to the House and resign when serious errors occur. Parliamentary questions, select committees and the Public Accounts Committee provide ongoing scrutiny, while the civil service implements policy on behalf of ministers operating under a duty of impartiality and political neutrality. Accountability in the UK Constitution is twofold. It is political, through Parliament's power to question, censure and ultimately remove a government, and it is legal, through the court's power to ensure that public authorities act within the limits of the law. This is where judicial review comes in, the mechanism by which judges supervise the exercise of public power. Judicial review doesn't challenge political decisions on their merits. It ensures that decisions are made lawfully, rationally and fairly. It is, in essence, the legal expression of the rule of law itself, an assurance that no one, not even the state, stands above the law.
The status of the devolved institutions and their relationship with Westminster. Devolution reshaped the constitutional landscape of the United Kingdom, transferring both lawmaking and executive powers to the Senate Cymru and the Welsh Government within what is known as a reserved powers model. Under this system, Westminster remains legally sovereign. It retains the ultimate authority to legislate on any matter. Yet in practice, sovereignty operates alongside political restraint. By long-standing constitutional convention, Westminster does not normally legislate in devolved areas without the consent of the Senate. That consent is given through what's called a legislative consent motion, a formal acknowledgement that the devolved legislature agrees to Westminster's intervention. The dividing line between what is reserved to Westminster and what is devolved to Wales is set out in the Wales Act 2017. It's a schedule that functions like a map of constitutional boundaries. Anything listed there remains under Westminster's control, and anything not listed falls within the Senate's competence, subject, of course, to certain constraints. Devolved powers must be exercised consistently with the European Convention on Human Rights and within the framework of the single legal jurisdiction of England and Wales. In practice, the boundary between devolved and reserved powers is not a wall, but a carefully negotiated frontier. Policy areas such as transport, agriculture, health, and the environment often overlap, and managing those overlaps requires constant dialogue between governments. Intergovernmental relations, common frameworks, and memoranda of understanding have developed to coordinate policies, share information, and prevent unnecessary conflict. These mechanisms help preserve the coherence of the United Kingdom, while still allowing each nation to experiment, adapt, and develop its own solutions. Devolution, in that sense, is both a test and a testament of constitutional flexibility, and a testament to the UK's capacity to accommodate diversity within unity.
The monarch and the crown, constitutional conventions and prerogative powers. In the modern British Constitution, the monarch reigns but does not rule. The crown remains the legal foundation of government. It is the enduring legal personality through which executive power is exercised, but the day-to-day business of governing lies firmly in the hands of ministers who command the confidence of the House of Commons. This arrangement depends on a delicate web of constitutional conventions that keep the machinery of state running smoothly. The monarch acts on the advice of ministers, never on personal initiative. The Salisbury-Addison Convention restrains the House of Lords from blocking legislation promised in a government's election manifesto. The Sewell Convention restrains Westminster from legislating in devolved areas without the consent of the devolved legislature. None of these conventions are legally enforceable. You cannot go to court to compel obedience, yet they're politically binding, shaping conduct through shared constitutional expectation rather than legal compulsion. Then there are the royal prerogative powers, the historic remnants of the monarch's original authority that still form part of the executive toolkit. These include the making of treaties, the defence of the realm, the grant of honours, and the conduct of foreign affairs. Over time, many prerogatives have been limited, transferred, or replaced by statute, but those that survive do so only to the extent that Parliament has displaced them. Today, prerogative powers operate within a framework of accountability and legality. Ministers exercise them, not the monarch, and must answer to Parliament for their decisions. The courts, meanwhile, play a supervisory role. They do not question the merits of high policy, but they will ensure that prerogative powers are used lawfully and for proper purposes. And when prerogative power collides with statute, the rule is clear: statute prevails. What was once the personal power of the Crown has evolved into a carefully constrained instrument of responsible government, controlled by convention, accountable to Parliament, and subject to the rule of law. Parliamentary privilege. Parliamentary privilege sits at the heart of the constitutional balance between Parliament and the courts. It exists to protect the independence of the legislature, to ensure that Parliament can carry out its work of debate, scrutiny, and lawmaking without interference from outside. The foundation of this privilege lies in Article 9 of the Bill of Rights 1689, which famously declares that proceedings in Parliament ought not to be impeached or questioned in any court. In plain terms, that means what happens inside Parliament, the debates, the votes, the speeches, cannot be challenged or examined by judges. This safeguard ensures that members can speak freely, criticise government, and debate controversial matters without fear of being sued or prosecuted for what they say. It is, in effect, a constitutional guarantee of free speech within the walls of Westminster. Privilege also covers what's called exclusive cognizance, Parliament's right to manage its own internal affairs without external interference. This includes the conduct of its members, the work of its select committees, and the rules governing its proceedings. Yet this autonomy is not unlimited. The modern understanding of privilege recognises that it extends only as far as is necessary to protect the core functions of Parliament, the freedom to legislate and to hold government to account. Where matters fall outside that core, the rule of law remains paramount. For practitioners, the message is clear. You cannot rely on statements made in Parliament to support a defamatory claim, nor can you bring litigation that seeks to challenge how a select committee conducted its business except in the most exceptional and narrowly defined circumstances. The celebrated case of Pepper v. Hart does not undermine this principle. It simply allows courts in limited situations to refer to ministerial statements in Parliament to clarify ambiguous statutory wording. This does not mean questioning or criticising what was said. Rather, it treats those statements as interpretive aids, helping judges understand Parliament's intention without trespassing on its privilege. In short, parliamentary privilege protects the freedom of the legislature to speak, debate and decide, a living reminder that in the British Constitution, the independence of Parliament and the rule of law stand side by side, each reinforcing the other.
Legitimacy, separation of powers and the rule of law. The UK Constitution rests on three great pillars: democratic legitimacy, the separation of powers and the rule of law. Together, they give authority to government and protection to the governed. Unlike a presidential constitution, the British model does not draw rigid boundaries between its branches of power. The legislator makes the law, the executive carries it into effect, and the judiciary interprets and applies it. Yet in practice, these functions often overlap. The executive proposes most bills that become Acts of Parliament. The Lord Chancellor still occupies a post that bridges politics and the judiciary. And judges, through the development of the common law, continue to shape legal principles that fill the gaps left by statute. But through all this interaction, one thing must remain constant: independence. Each branch must be free from improper influence by the others, particularly the judiciary, whose authority depends entirely on public confidence in its impartiality. Independence is the constitutional anchor that prevents power from drifting into abuse. At the core of this arrangement lies the rule of law, the idea that no power is absolute and that every exercise of authority must have a legal foundation. Public power must be used only for legitimate purposes, through fair procedures and under the scrutiny of an effective review system. The rule of law also demands that the laws themselves meet certain standards. They must be general, clear, prospective and publicly accessible. Only when citizens can know and understand the law can they be expected to obey it. And perhaps the most fundamental element of all, in the United Kingdom no one is above the law. Not ministers, not Parliament, not even the Crown. It is this shared submission to legality that gives the British Constitution both its authority and its moral strength.
Making, implementing and repealing primary and secondary legislation at Westminster and in Wales. So how does a bill become an act? The journey from proposal to law is both procedural and political, a careful dance between scrutiny, debate and consent. A government bill usually begins in either the House of Commons or the House of Lords. Its first reading is a formality, the bill is introduced and ordered to be printed, but no debate takes place. The real work begins at the second reading, where the House debates the general principles and purpose of the bill. If it survives that stage, it moves to committee, where members go through the text line by line, proposing amendments and testing its detail. After the committee's work, the bill returns to the floor for the report stage, where further changes can be made, followed by the third reading, a final review before it leaves that house. The process is then repeated in the other house, which can amend the bill in turn. When the two houses disagree, the text is sent back and forth, a process often called ping-pong, until both agree on identical wording. Once the final version is settled, the bill receives royal assent, transforming it into an Act of Parliament. Even then, the law may not come into force immediately. Commencement can take effect straight away, on a specified date, or later by ministerial order, allowing flexibility in timing and implementation.
Alongside acts sits a vast body of secondary legislation, also known as delegated legislation or statutory instruments. These are laws made by ministers or other authorities under powers granted by Parliament. Some statutory instruments require explicit parliamentary approval under the affirmative resolution procedure. Others take effect automatically unless annulled under the negative resolution procedure. This system allows Parliament to delegate technical detail to the executive while retaining ultimate control. In Wales, the process is much the same, but it takes place within the devolved framework. Senedd bills pass through similar stages of scrutiny, debate and amendment, and once enacted, become acts of the Senedd. Welsh ministers then make statutory instruments within devolved areas such as health, education and the environment, following procedures set by the Senate's standing orders and the governing legislation. Over time, laws evolve. They can be repealed or amended, either expressly, where a Parliament says so directly, or by implication, where a new law conflicts with an old one. Periodically, the statute book is tidied up through consolidation, gathering scattered provisions into a single coherent act. Full codification, bringing an entire area of law into one self-contained code, is rare in the common law tradition, but not impossible. It remains a kind of legislative ideal, order carved out of centuries of accreted complexity. Public order law sits at one of the most delicate intersections in the legal system, the meeting point between individual freedom and collective safety. It seeks to protect the right to protest, to assemble and to speak out, while also safeguarding the public from serious disorder, intimidation or disruption. The law's constant task is to balance liberty with order. When a public procession is planned, a march, rally or demonstration, organisers must give prior notice to the police. This isn't designed to discourage protest, but to allow for policing arrangements that keep everyone safe. Once notified, the police have the power to impose conditions on a procession where it's necessary to prevent serious disorder, serious disruption or intimidation. The same principle applies to static assemblies, gatherings in one place, where conditions may be imposed if the legal thresholds are met. In recent years, Parliament has refined and expanded these powers, responding to changing forms of protest. The law now defines serious disruption with greater precision and grants police new tools to manage tactics like locking on, gluing on or tunnelling to block roads, transport networks or critical infrastructure. Alongside these, civil orders, such as serious disruption prevention orders, target individuals with a history of causing repeated large-scale disruption. Yet through all these developments, one principle remains constant: proportionality. Any restriction on protest must go no further than is necessary to achieve a legitimate aim, whether that's public safety, the prevention of disorder, or the protection of the rights of others. Police decisions must be justified, recorded, and open to review. At common law, the concept of breach of the peace still survives. It allows preventative action, even without statutory authority where violence is actually occurring or is imminent. But modern policing and public order management rely increasingly on statute, with clearer powers, defined thresholds, and written reasons for action. For practitioners, the instinct should always be the same: test every restriction against the twin standards of necessity and proportionality, and look for clear statutory authority. The rule of law demands no less. Protest is a right, but a right exercised within the limits of lawful order.
Judicial review: nature, process, limits and remedies. Judicial review is the constitutional mechanism through which the High Court supervises the exercise of public power. It is not about whether a decision was wise or fair in the everyday sense, but whether it was lawful, whether the decision-maker had the power to act, stayed within that power, followed fair procedures, and reached a decision that was rational on the evidence before them. Judicial review ensures that government acts according to law, not whim. At its core, the court asks a series of disciplined questions. Did the authority have the legal power to act? Was that power used for its proper purpose? Were relevant factors considered and irrelevant ones ignored? Was the process procedurally fair? And was the decision one that a reasonable decision-maker could have reached? Not necessarily the best decision, but one within the lawful bounds of reason. Judicial review is not an appeal on the merits. The court does not substitute its own judgment for that of the public authority. Its task is to police legality, not policy. A claim for judicial review must be brought promptly and in any event within 3 months of the decision under challenge. Certain areas, such as planning or public procurement, have even shorter time limits. The requirement of standing or locus standi means the claimant must have a sufficient interest in the matter. This is interpreted generously where issues of public importance arise. Community groups, campaigners, and NGOs can have standing if the rule of law itself is at stake. What matters is not the label attached to the body being challenged, but the nature of the function it performs. Public law obligations follow the function, not the form. So a private company carrying out public functions, for instance, managing prisons, housing, or health services under contract, may still be amenable to judicial review. The remedies available are deliberately flexible, allowing the court to tailor its response to the circumstances. The court may issue a quashing order, setting aside the unlawful decision, a prohibiting order, preventing future unlawful action, or a mandatory order compelling the performance of a public duty. It can make a declaration to clarify the law and guide future conduct, or an injunction to restrain continuing illegality. Damages are exceptional in judicial review. They are awarded only if another cause of action, such as a breach of statutory duty or a claim under the Human Rights Act 1998, provides a route to compensation. Recent reforms have introduced suspended and prospectively only quashing orders, giving courts discretion to delay or limit the effect of nullifying an unlawful act, where immediate cancellation would cause disproportionate disruption. But the default principle remains the same. An unlawful act is voidable, and unless there is good reason not to, it will be set aside. Judicial review, then, is not a weapon of politics, but a safeguard of principle, the rule of law in action, ensuring that those who wield public power do so within the limits that law, reason, and fairness demand.
Grounds of review: illegality, irrationality, procedural impropriety, and legitimate expectation. The grounds of judicial review define the limits of lawful public decision-making. They are not rigid categories, but flexible principles that guide how courts assess whether power has been exercised properly. 4 of the most significant are illegality, irrationality, procedural impropriety, and legitimate expectation. Illegality occurs when a public authority steps outside the powers that Parliament intended it to have. A decision-maker acts unlawfully if they use a power for a purpose other than that for which it was conferred, if they misdirect themselves in law, or if they fetter their discretion by adopting an inflexible policy that refuses to consider exceptions. Public bodies must always be open to the particular facts of each case. Delegated powers are not personal gifts. They are held in trust for the public to be exercised only within the boundaries set by statute and principle. Irrationality, sometimes called Wednesbury on reasonableness, captures decisions so unreasonable that no reasonable authority, properly directing itself, could ever have made them. This is an exacting standard, not a license for courts to second-guess administrative choices. However, the intensity of review varies with context. Decisions affecting fundamental rights or vital interests attract closer scrutiny, while those involving complex policy, national security, or economic judgment are reviewed with restraint. The guiding idea is proportionality between the importance of the issue and the depth of judicial intervention. Procedural impropriety focuses on fairness in the process rather than the outcome. It includes failures to follow mandatory statutory procedures, breaches of natural justice such as bias or the appearance of bias, and the denial of a fair hearing where fairness requires one. The hallmark of good administration is not just that decisions are lawful, but that they are made transparently, impartially, and with an open mind. Finally, legitimate expectation bridges procedure and substance. It arises when a public authority, through an express promise, a consistent past practice, or a published policy, creates a reasonable expectation that it will act in a particular way, perhaps by consulting before changing policy, giving reasons before taking action, or even delivering a specific benefit or outcome. Where such an expectation exists, fairness may require the authority to honour it unless an overriding public interest justifies a change of course. The doctrine protects trust between citizen and state. Government may change its mind, but it must do so fairly, with candour and justification. Together, these grounds form a single principle in action that public power is never absolute. It must be exercised for lawful purposes, in a rational way, through fair procedures, and in good faith towards those it affects.
Decisions that may be challenged and the scope of the supervisory jurisdiction. Judicial review reaches across the full landscape of public administration.
Any body exercising public power, whether central or local, statutory or delegated, may find its decisions tested against the standards of legality, rationality, and fairness. The range is broad. Decisions by central government departments, local authorities, regulators, police forces, NHS trusts, school governors, prison authorities, and a host of other public bodies are all amenable to judicial review. What matters is not the label attached to the body, but the nature of the function it performs. If a private organisation is carrying out a task that is essentially public, for example, managing detention centres, running social housing, or delivering healthcare under government contract, its decisions may equally be subject to the court's supervisory jurisdiction. Public law follows function, not form. Even so, courts exercise restraint. They recognise that some areas, high policy, foreign affairs and national security, for instance, lie close to the heart of the political process, where ministers must answer primarily to Parliament, not the judiciary. Yet even there, the rule of law has reach. Judges will still ensure that decisions are lawful, rational and procedurally fair, even if they avoid pronouncing on the wisdom or expediency of policy itself. When governments seek to insulate decisions from review through ouster clauses, statutory provisions that attempt to exclude the jurisdiction of the courts, the judiciary reads them with great care. Only the clearest words can exclude judicial supervision, and even then, only within constitutional limits. The courts have made plain that total exclusion of judicial review would undermine the very rule of law on which Parliament's authority itself depends. There are times, however, when Parliament deliberately creates a specialist appellate route within a statutory scheme, for instance, to challenge planning, immigration, or regulatory decisions. Where such an alternative mechanism exists, claimants will usually be expected to use it rather than resort to judicial review. The High Court will step in only where the issue is of jurisdiction, meaning that the decision-maker acted wholly outside its powers, or where the statutory process cannot cure a fundamental unfairness. In short, judicial review is both wide and disciplined. It reaches wherever public power is exercised, but it does so with respect for constitutional boundaries, ensuring that the courts remain guardians of legality without straying into the territory of governance itself.
Standing and time limits. To bring a claim for judicial review, a claimant must cross two key thresholds, standing and timing. These are not mere procedural details. They reflect the balance between access to justice and the need for certainty in public administration. The requirement of standing means that the claimant must have a sufficient interest in the matter. Judicial review is not confined to those with a personal injury or private grievance. It is about the lawfulness of public action, not the vindication of private rights. This means that public law charities, campaign groups, and NGOs can have standing, where their focus is on ensuring that government acts within the law. The courts have recognized that the rule of law sometimes needs guardians beyond those directly affected. That said, standing is not unlimited. Judicial review is not a stage for purely academic challenges or abstract disputes. The court will ask whether there is a real practical stake in the outcome, and whether the issue is justiciable, that is, suitable for resolution by legal principles rather than political debate. The claimant must show that the question raised is both concrete and properly within the court's remit. Timing is equally strict. Claims must be brought promptly and in any event within 3 months of the decision being challenged. This reflects the need for good administration and certainty. Public authorities and third parties must be able to rely on decisions once made. Courts will grant extensions of time only sparingly, and they weigh any prejudice to good administration very heavily. The longer a claimant delays, the harder it becomes to justify intervention. Certain areas have even tighter rules. Planning decisions and public procurement challenges have their own bespoke shorter deadlines, often measured in weeks rather than months. And where Parliament has created a statutory appeal process for a particular kind of decision, that route will usually take precedence, leaving judicial review as a remedy of last resort. Standing and timing, then, are the gatekeepers of judicial review, ensuring that challenges are brought by those with a genuine interest at the right time and in the right way, so that the courts can protect legality without paralysing the machinery of government.
The Human Rights Act 1998 and the European Convention on Human Rights. The Human Rights Act 1998 transformed the landscape of public law by weaving the rights of the European Convention on Human Rights directly into the fabric of UK law. Before the Act, those alleging a breach of their convention rights had to take their case to Strasbourg.
Now, the same rights can be argued and enforced before domestic courts in England and Wales, Scotland and Northern Ireland, a profound constitutional shift that made human rights an everyday part of British legal reasoning. When a court is asked to decide a question involving a convention right, it must take into account the jurisprudence of the European Court of Human Rights. This does not mean blind obedience. UK courts treat Strasbourg decisions with respect, not reverence. They aim to follow the general principles laid down by the European Court, while retaining the autonomy to apply them within the distinctive framework of domestic law and the constitutional traditions of the United Kingdom. Section 3 of the Act gives judges a powerful interpretative tool. Legislation must, so far as possible, be read and given effect in a way compatible with convention rights. This duty applies to all courts and tribunals and extends across all primary and secondary legislation. Where such a reading simply cannot be achieved, where words cannot be bent without breaking the meaning of the statute, the higher courts may issue a declaration of incompatibility. A declaration does not strike down the statutes. The doctrine of parliamentary sovereignty remains intact. Instead, the declaration signals to Parliament that the law as enacted sits uneasily with the UK's human rights obligations and invites legislative correction. This careful balance between judicial scrutiny and parliamentary supremacy reflects the Act's constitutional subtlety. The courts illuminate, but Parliament decides. Public authorities, for their part, are under a positive duty to act compatibly with convention rights unless compelled otherwise by primary legislation that leaves no room for compliance. This duty extends beyond central government and local councils to include the police, NHS bodies, schools, prisons, and even private organisations performing public functions. An individual who claims to be a victim of an unlawful act by a public authority can bring proceedings under the Act or rely on their convention rights in any other legal proceedings. The courts may grant whatever remedy is just and appropriate, including damages where necessary to afford just satisfaction, though damages remain the exception rather than the rule. Where incompatibility is formally declared, remedial orders provide a streamlined way for Parliament to amend the offending legislation. Schedule 1 to the Act sets out the rights themselves: the right to life, the prohibition of torture and inhuman or degrading treatment, the right to liberty and security, the right to a fair trial, respect for private and family life, freedom of thought, conscience and religion, freedom of expression, assembly and association, protection of property and the right to education, among others. These rights, once distant and international, now speak directly within domestic law. For the practitioner, the habit must be to think Human Rights Act early. Ask, is there a public authority involved? Which right is engaged? Has there been an interference? And if so, is it prescribed by law, pursuing a legitimate aim, and necessary in a democratic society? And finally, what remedy is realistically available and proportionate? The Human Rights Act does not replace the common law or the Constitution. It enriches both, infusing legal reasoning with principles of dignity, fairness, and proportionality. It ensures that government, however powerful, remains answerable to the individual whose rights it affects.
The place of EU law in the UK Constitution after Brexit. Although the United Kingdom has left the European Union, the influence of EU law continues to ripple through almost every area of legal practice. Brexit did not wipe the slate clean, it froze and reshaped it. Through the European Union Withdrawal Acts 2018, Parliament ensured that at the end of the transition period, a vast body of law known as retained EU law was carried forward into domestic law. This body preserved the effect of EU regulations, directives implemented through UK legislation, and related case law as they stood on exit day, so that legal continuity would not collapse overnight. This retained law was not static. Subsequent reforms have refined and rebranded it, giving rise to the term assimilated law, a category that reflects both continuity and adaptation. The aim was to domesticate what had been EU law, removing its supranational character and reasserting the authority of UK institutions to amend, interpret, and develop it going forward. Assimilated law remains rooted in its EU origins, but its constitutional footing has shifted. It is now UK law, subject to UK principles of interpretation and modification.
Before Brexit, the supremacy of EU law meant that, in case of conflict, directly effective EU provisions took precedence over inconsistent domestic statutes. That principle no longer applies to new legislation made after the UK's departure. While supremacy still governs the interpretation of pre-exit conflicts to preserve legal certainty, it no longer operates prospectively. From 2021 onwards, Parliament's sovereignty is restored in full, and new Acts of Parliament take unquestioned precedence within the domestic hierarchy. Equally, UK courts no longer make references to the Court of Justice of the European Union. Questions of EU law interpretation now rest entirely with the domestic judiciary. However, the Withdrawal Act preserved the body of pre-Brexit CJEU case law, making it binding on most courts unless and until departed from by higher authority. The Supreme Court and the Court of Appeal now have express power to depart from retained EU case law where they consider it right to do so, balancing the need for legal stability with the freedom to evolve beyond the EU framework.
Central government accountability, ministerial powers and prerogative in practice. Accountability in the British Constitution works like a series of concentric circles, each one enclosing the next. At the centre stand the ministers of the Crown, accountable in three distinct ways. They are politically accountable to Parliament, legally accountable to the courts, and ethically accountable to established codes of conduct. These overlapping forms of scrutiny ensure that power, though centralised, is never absolute. In the political sphere, ministers must answer to Parliament through questions, debates, select committee inquiries, and ultimately the confidence of the House of Commons. Political accountability does not depend on legal wrongdoing. It is about transparency, responsibility, and the maintenance of trust in democratic government. Legal accountability operates through judicial oversight. The courts can examine whether ministers and public bodies have acted within the powers conferred by law, the principle of ultra vires, or acting beyond legal authority. This extends to secondary legislation, which may be challenged for exceeding the scope of the parent act, for procedural defects in its making, or for unreasonableness in substance. The same principles apply to prerogative powers, such as those concerning foreign affairs, passports, or national security. Where such powers are justiciable, courts can review them on familiar public law grounds: legality, rationality, procedural propriety, and respectful legitimate expectation. Parliament may also choose to curtail or replace prerogative powers by statute, reinforcing the supremacy of law over executive discretion. Beneath a ministerial level, the civil service operates under its own code, requiring impartiality, integrity, objectivity, and honesty. Every public body, from regulators to local councils to schools, prisons, and NHS trusts, must act within the limits of its founding statute, guided by the overarching principles of public law. For practitioners advising public authorities, the golden rule is prevention before litigation. That means ensuring fair consultation where fairness demands it, publishing clear and consistent policies, taking relevant matters into account, avoiding irrelevant ones, giving intelligible reasons for decisions, and keeping a defensible record of the decision-making process. A well-documented and proportionate approach is the best protection against successful challenge. For those advising claimants, accountability has its own tactical logic. The key is to choose wisely the right defendant, the right round of challenge, and the right remedy, and to act quickly within the time limits that judicial review imposes. In both public administration and litigation, accountability is not merely a control mechanism, but a discipline, one that builds lawful, transparent, and reasoned governance, and reinforces public confidence that those who wield power remain answerable to the law.
Parliamentary procedure, delegated powers and scrutiny in Westminster and the Senate. The quality of legislation depends less on the words on the page than on the process that produces them. Sound legislative process is the foundation of legal certainty and public confidence. When Parliament delegates lawmaking powers to ministers, those powers must be specific, proportionate, and subject to proper scrutiny. Broad skeleton clauses, which leave the substance of regulation to be filled in later, risk undermining accountability. They invite both political criticism and legal challenge on grounds of vagueness or excessive delegation. Different forms of parliamentary procedure reflect different levels of scrutiny. Under the affirmative procedure, an instrument must be expressly approved by Parliament before it can take effect, ensuring debate and visibility. The negative procedure, by contrast, allows an instrument to become law automatically unless Parliament actively prays to annul it within a defined period, so its effectiveness depends on vigilance from backbenchers and committees. The super-affirmative procedure, used rarely for matters of high significance, goes further by requiring draft consultation and pre-enactment scrutiny before the regulation is made. In Wales, the Senate follows similar scrutiny routes, adapted to its devolved context. Because Welsh legislation governs key aspects of daily life, education, health, housing, the environment, the clarity of explanatory material and the precision of bilingual drafting are of exceptional importance. Lawyers must treat the English and Welsh texts as equally authoritative, reading both where meaning diverges and aligning interpretation with legislative purpose. For the practitioner, the discipline is always to read in layers. First, the empowering act, then the procedure used to make the delegated legislation, and finally the instrument itself, paying close attention to commencement dates, territorial extent, and any transitional arrangements that determine how and when the rules bite. Judicial review sits alongside this structure as the system's supervisory safeguard, not an appeal on the merits. Courts do not substitute their own policy preferences for those of elected or expert decision-makers, particularly where statutes entrust matters of technical complexity or resource allocation to specialized bodies. Yet the courts ensure that all decision-makers remain within the legal boundaries of their powers, act fairly and rationally, and respect fundamental rights. The intensity of review varies with the subject matter. Where human rights or liberty are engaged, proportionality demands closer scrutiny. Where Parliament has allocated scarce resources, rationality review is more restrained.
Remedies in judicial review remain discretionary and attuned to good administration. Increasingly, courts make use of suspended or prospective-only quashing orders, allowing public bodies to correct legal defects without destabilizing complex regulatory schemes or invalidating decisions retroactively. This reflects a modern, pragmatic balance between legality and continuity. Beyond formal law, constitutional conventions provide the soft tissue around the constitutional skeleton. They describe how public actors behave when the black-letter law is silent or too blunt. Conventions operate on trust and shared understanding. The monarch acts on ministerial advice, ministers resign for departmental failures, and Westminster seeks devolved consent before legislating on devolved matters. Breaching a convention carries no legal penalty, but the political cost can be immense, and persistent breach corrodes the working constitution itself. For lawyers, conventions matter because they shape both the ethics of governance and the expectations of stability on which markets, institutions, and communities depend. When advising government, one must ask not only can we do it, but also should we do it and what will happen if we do. When advising clients affected by regulation, an awareness of convention underpins confidence in the predictability of public action. These principles converge vividly in modern protest law, where questions of human rights, public order, and administrative discretion collide. Imagine a protest group planning a disruptive march. The police, invoking their statutory powers, impose conditions to prevent serious disruption. The organizers claim a breach of their freedoms of expression and assembly under the Human Rights Act. The court's task is to apply the familiar proportionality test. Is the restriction prescribed by law? Does it pursue legitimate aims, such as public safety or the protection of others' rights? And is it necessary and proportionate in the circumstances? That analysis folded naturally into the public law framework. Did the police consider all relevant factors, apply the statutory tests correctly, act within their powers, and provide reasons capable of withstanding scrutiny? The remedy might be a declaration, the quashing of particular conditions, or an urgent interim order to pause enforcement until the lawfulness of the restriction can be determined. Here, the abstractions of the constitutional theory meet the immediacy of real life, where protest, power, and principle collide in the streets, and the courts mediate between liberty and order in the language of legality and reason.
Conclusion. The legal system of England and Wales is at once continuous and dynamic. It honours precedent but adapts by distinguishing and by overruling where necessary. It respects parliamentary sovereignty but commits to the rule of law and human rights. It speaks with a single jurisdictional voice, even as it allows Wales to legislate distinctly within devolved competence. It has stepped out of the EU while carrying forward a large body of EU-derived rules as domestic law.
It empowers protest while protecting order. It keeps public authorities within the law without substituting judicial preferences for democratic choices. For SQE practice, your craft is to move easily among these layers. Read acts fluently, interpret purposefully, argue precedent honestly, and deploy judicial review with precision and restraint. Do that and you will be the kind of newly qualified solicitor this system expects. Practical, principled, and effective.
Office romance is usually just frowned upon. But in the world of legal services, that same romance can cost you your entire livelihood.
A partner at a major international law firm had a consensual intimate encounter with a junior colleague. It happened after work, in private, with no clients, no legal files, no courtroom in sight. Yet the Solicitors Regulation Authority decided that this private moment was their business. They sanctioned him for failing to act with integrity and for damaging public trust in the profession. His personal life became a regulatory case. His relationship choices became evidence. His reputation and his career hung in the balance. The case went all the way to the courts, which eventually pushed back, saying the SRA had overreached, but the warning shot was unmistakable. When you become a solicitor, your professional obligations do not clock out at 5 p.m. In this profession, the border between your working life and your private life isn't a line, it's a tripwire. And that is why the SQE puts such a heavy emphasis on ethics, because in legal services, who you are outside the office can be just as dangerous as what you do inside it. Welcome to this lecture on the regulation of legal services in England and Wales. This material forms the structural bedrock on which all substantive legal practice rests. For candidates preparing for the solicitor's qualifying examination, particularly the FLK1 assessment, the topic of legal services often feels meta, because it governs the very existence, behaviour and business models of the solicitor's profession. It is not simply an irritating layer of bureaucracy sitting on top of real law. It is a dynamic, high-stakes environment in which statutory obligations, ethical duties, and commercial realities intersect constantly in day-to-day practice. As of late 2025, this landscape has tightened markedly, shaped by reforms such as the Economic Crime and Corporate Transparency Act 2023, enhanced money laundering supervision, and a sharper enforcement stance from the Solicitors Regulation Authority. What follows is a comprehensive, integrated narrative of that framework designed to match the SRA specification for FLK1. It traces the tiered regulatory structure created by the Legal Services Act 2007. It explains how the principles and the Statement of Solicitor Competence frame everything a solicitor does, explores the pervasive reach of anti-money laundering regimes, examines the interaction between legal practice and financial services regulation, and unpacks the economics of funding legal work. Along the way, it highlights important developments from 2024 and 2025, such as the delay to the legal aid means test review, the commencement of the corporate offence of failure to prevent fraud, and key judicial decisions on damages-based agreements and litigation funding.
The regulatory role of the SRA. The starting point for understanding the regulatory architecture is the Legal Services Act 2007 and the reforms associated with the Clementi Review. Under the old system, the Law Society effectively played a dual role, both as representative body for solicitors and as regulator. The Clementi reforms concluded that this model risked prioritizing the interests of the profession over those of the public. The Legal Services Act therefore created an institutional hierarchy that separates oversight, regulation, and representation. At the top sits the Legal Services Board, an independent oversight body with statutory objectives such as protecting and promoting the public interest, improving access to justice, promoting competition in legal services, and encouraging an independent, strong, and effective legal profession. The Legal Services Board supervises approved frontline regulators, but does not regulate individual solicitors directly. That task falls primarily to the Solicitors Regulation Authority. Legally, the SRA is an arm of the Law Society, but it operates with substantial operational independence. It regulates over 100,000 solicitors and thousands of firms in England and Wales. The Law Society, stripped of its regulatory functions, now operates as a representative body. It lobbies, advises, and supports the profession. For SQE purposes, it is essential to keep this distinction clear. The SRA sets and enforces standards. The Law Society represents solicitors. When you are asked in an exam scenario which body investigates misconduct or issues practicing conditions, the answer is the SRA, not the Law Society.
Principles and risk-based regulation. The SRA regulates on two levels. At the high level stand the SRE principles, which function as the ethical constitution of the profession. Below them sit the detailed codes of conduct, one for solicitors and one for firms. The SRA makes it clear that the principles are fundamental tenets of ethical behavior and are mandatory. They apply to authorized persons and firms at all times, and they apply even outside purely professional contexts. If a solicitor's private conduct undermines public trust or breaches the principles, regulatory action can still follow. Where there is a conflict between a principle and some other provision in the rules, the principle prevails. As of 2025, the SRA principles can be understood as 7 core duties. First, a solicitor must act in a way that upholds the constitutional principle of the rule of law and the proper administration of justice. This is the paramount obligation. If a client's instructions would require the solicitor to mislead the court, to suppress evidence that must be disclosed, or otherwise to interfere with the administration of justice, the duty to the court overrides the duty to the client. The solicitor serves the court and the legal system first, and the client second. Second, a solicitor must act in a way that upholds public trust and confidence in the profession and in the provision of legal services generally. This principle reaches into the solicitor's private life. Disciplinary tribunals have repeatedly sanctioned solicitors for matters such as dishonesty in personal financial dealings, criminal convictions for drink driving or assault, and abusive behavior on social media on the basis that such conduct damages public trust in the profession. Third, a solicitor must act with independence. Professional judgment must not be compromised by the interests of third parties, funders, employers, or powerful clients. This is particularly important in contexts such as referral arrangements, managed litigation, or group actions, where commercial pressures may push a solicitor towards a course of action that suits a referrer or funder, but is not in the client's best interests. The solicitor must resist those pressures. Fourth, a solicitor must act with honesty. Honesty is treated as an absolute. Where a tribunal makes a finding that a solicitor was dishonest, meaning they subjectively knew that what they were saying or doing was false, and their conduct would be considered dishonest by the standards of ordinary decent people, the usual outcome is removal from the role. Honest mistakes can be remedied. Dishonesty is treated as fundamentally incompatible with continued practice, save in the most exceptional circumstances. Fifth, a solicitor must act with integrity. Integrity is a broader and more nuanced concept than honesty. A solicitor may avoid outright lying and yet still fail to act with integrity. For example, allowing the court or an opponent to labour under a serious misconception that benefits the client, exploitatively taking advantage of an obvious clerical error in a way that is manifestly unfair, or drafting documentation that deliberately obscures critical risks, can all be treated as a lack of integrity even if no blatant falsehood is spoken. Sixth, a solicitor must act in a way that encourages equality, diversity, and inclusion. This has moved beyond a passive duty not to discriminate into a proactive obligation to foster inclusive workplaces and client environments. It dovetails with the Equality Act 2010, which prohibits discrimination, harassment, and victimization on grounds such as race, sex, disability, religion or belief, and other protected characteristics. If a firm fails to address harassment, tolerates discriminatory practices in recruitment or promotion, or operates in a way that consistently disadvantages particular groups of clients, that is not merely a civil risk, it is a regulatory breach of this principle as well.
Seventh, a solicitor must act in the best interests of each client. This underpins the entire solicitor-client relationship, but it is meaningful that it appears after the other principles. The ordering is symbolic.
Acting in the client's best interests never justifies breaking the law, misleading the court, acting without integrity, or undermining equality and inclusion. The client's interests are extremely important, but they are not absolute. Alongside the principles, the Statement of Solicitor Competence defines the standard of safe practice. Qualification through the SQE is an entry point, not the end of learning. The Statement of Solicitor Competence requires solicitors to maintain their knowledge and skills, to identify the limits of their competence, to obtain appropriate supervision, and to resist pressure to act beyond their expertise or in breach of ethical norms. For an SQE candidate, the Statement of Solicitor Competence is the reference point for what a competent, newly qualified solicitor should do in scenario-based questions. If a hypothetical solicitor with no tax expertise accepts a complex corporate tax instruction without seeking specialist assistance, that is not just a bad career move, it is a regulatory problem because the solicitor is acting outside their competence and risking serious harm to the client. The SRA's approach to enforcement is explicitly risk-based. It recognizes that it cannot investigate every minor lapse, so it concentrates resources on the areas where risks to the public and the rule of law are greatest. These include misuse of client money, failings in anti-money laundering systems, poor treatment of vulnerable consumers, and behavior that undermines trust in the profession. In recent years, and especially following the Economic Crime and Corporate Transparency Act 2023, the SRA's enforcement toolkit has been strengthened. One of these striking changes is that the statutory cap on financial penalties for economic crime-related breaches has been removed. Where previously fines for traditional firms were generally capped at a relatively modest level, the SRA can now impose unlimited financial penalties for serious failings linked to money laundering, sanctions breaches, and related misconduct. This sends a clear message that the profession is expected to play a robust gatekeeping role and that deliberate or reckless facilitation of economic crime will not be treated as a minor regulatory hiccup. In parallel, the SRA has refined its supervision and audit processes. In the accounts rules context, the 2025 focus has fallen on two practical indicators: 5 weekly kind account reconciliations and the handling of residual balances. Rule 8.3 requires reconciliations at least every 5 weeks, and the SRA now treats these as fixed milestones rather than vague expectations. Persistent lateness, superficial review, or a failure to act on reconciliation discrepancies can trigger deeper regulatory scrutiny, because they may indicate broader weaknesses in governance and financial stability. Residual balances, small sums left lingering on client accounts at the end of a matter, are also a concern. Firms are expected to return client money promptly once there is no continuing reason to hold it. Using client accounts as quasi-banking facilities, or simply failing to clear old balances for years, is seen as unacceptable.
Reserved legal activities. To understand how far the solicitor's monopoly extends, it is necessary to turn to the concept of reserved legal activities under the Legal Services Act 2007. The word lawyer is not protected, and in many areas anyone can offer legal advice. An unregulated advisor can explain unfair dismissal law, draft the basic contract, or even prepare a will. However, to protect the public in particularly sensitive areas, Section 12 and Schedule 2 of the Act create 6 categories of reserved legal activity. Performing these without authorization or holding oneself out as authorized to do so when one is not is a criminal offense. The 6 reserved activities can be described in narrative form. The first is the exercise of a right of audience. This means the right to appear before a court as an advocate, to address the judge, and to examine or cross-examine witnesses. Solicitors who have qualified for rights of audience in the criminal and civil higher courts may appear in those courts. Solicitors and certain other authorized persons have rights of audience in the lower courts as part of their general authorization. The second reserved activity is the conduct of litigation. This includes issuing proceedings, commencing, prosecuting and defending claims, and handling the formal procedural steps such as filing documents and managing correspondence on the court record. Advising a client about whether to sue or settle is not itself reserved, but formally running the litigation is. The third reserved activity is the category known as reserved instrument activities. This is essentially the technical heart of conveyancing. It covers preparing instruments of transfer or charge in relation to registered land under the Land Registration Act 2002 and certain related land registration functions.
The fourth reserved activity relates to probate. It is not will writing as such, but the preparation of probate papers for the purpose of the law of England and Wales, or for proceedings for a grant of representation. The fifth reserved activity comprises notarial services. Notaries, who are regulated separately, authenticate and certify documents for use abroad, among other functions. Finally, the administration of oaths is a reserved activity. Swearing affidavits and statutory declarations and taking certain formal oaths may only be carried out by authorized persons, such as solicitors with the relevant status or commissioners for oaths. The way these reserved activities interact with unregulated work creates a complex market. Unregulated providers can carry out substantial volumes of legal work as long as they avoid reserved activities and do not mislead the public about their status. At the same time, law firms may unbundle services, allowing clients to handle some aspects of a case themselves, while the firm retains responsibility for the portions that involve reserved work. This unbundling can improve access to justice, but creates regulatory risk. If an unadmitted paralegal effectively runs a litigation file with minimal supervision, that may amount in substance to the conduct of litigation by an unauthorized person. If an unregulated advisor appears in court in circumstances where reserved rights of audience are required, the criminal provisions of the Legal Services Act may be engaged. In exam scenarios, it is important to be alert to the offence of holding out. Even if someone does not actually carry out a reserved legal activity, they commit an offence if they hold themselves out as entitled to do so, or as being a solicitor when they are not. Advertising oneself as solicitor or law firm without authorization is serious because the public relies on those titles as markers of regulatory protection. Other regulators of legal services. The SRA is not the only frontline regulator. The Bar Standards Board regulates barristers. The Council for Licensed Conveyancers regulates specialist conveyances. SILEX regulation oversees chartered legal executives who increasingly can obtain independent practice rights in specific fields such as conveyancing or probate without needing direct solicitor supervision. Their step has eroded the traditional hierarchy where solicitors sat unambiguously at the top of the tree. In addition, the Legal Services Act introduced alternative business structures. These are entities in which non-lawyers can be owners or managers and where legal services may be offered alongside other professional services such as accountancy or financial planning. An ABS still requires authorization and is subject to the same principles and codes of conduct, but it must also appoint a compliance officer for legal practice, COLP, and a compliance officer for finance and administration, COFA, and it must hold an ABS license. The ABS model opens the door to external investment and multidisciplinary practices while preserving regulatory standards.
Combating money laundering. Anti-money laundering and financial crime compliance sit at the intersection of criminal law and regulatory obligations. The legal profession is formally recognized as high risk for money laundering because solicitors handle client money, facilitate property transactions, create companies and trusts, and act as intermediaries in complex cross-border deals. At the heart of the criminal regime is the Proceeds of Crime Act 2002. This statute defines money laundering offences in extremely broad terms. Criminal property covers any property that constitutes or represents, directly or indirectly, a person's benefit from criminal conduct, if the alleged money launderer knows or suspects that it is such a benefit. The predicate conduct can be almost any crime and may have occurred abroad, provided it would also be criminal under UK law. Poker sets out three principal money laundering offences that are especially important for solicitors. The first is the offence under Section 327, often described as concealing. It covers concealing, disguising, converting, transferring or removing criminal property from the jurisdiction. A solicitor here knowingly transfers funds derived from fraud through a client account to another jurisdiction commits this offence. The second is the arrangements offence in Section 328. This is particularly significant for the profession because much transactional work can be characterised as entering into arrangements. The offence applies where a person enters into or becomes concerned in an arrangement which they know or suspect facilitates the acquisition, retention, use or control of criminal property by or on behalf of another person. A solicitor who structures a transaction in a way that they suspect is intended to help the client integrate the proceeds of crime into the legitimate economy risks liability under this section. The third principal offence under Section 329 covers acquiring, using or possessing criminal property. In theory, even receiving fees paid with the proceeds of crime can fall under this section, though there are complex issues about adequate consideration and de minimis thresholds that are beyond the scope of most SQE questions. The mental element for these offences is knowledge or suspicion. Suspicion is a relatively low threshold. It requires that the solicitor thinks there is a possibility, which is more than fanciful, that the property is the proceeds of crime,
There is no requirement that they be certain. This low threshold is deliberate because the money laundering regime expects professionals in high-risk sectors to err on the side of caution. Alongside these principal offences, POCA imposes obligations on those who work in the regulated sector, solicitors doing transactional work, for example, to make disclosures where they know or suspect money laundering. The failure to disclose offence in Section 330 arises where a person receives information in the court of regulated business, which gives them knowledge or suspicion, or reasonable grounds for knowledge or suspicion, of another's money laundering, and they do not make the required report. This introduces an objective element. A solicitor can be criminally liable even if they did not in fact suspect money laundering, if the reasonable person in their position would have done so based on the same facts. In practice, this means that ignorance is not a safe defence if the warning signs were obvious. Once a suspicion arises, the solicitor must usually make an internal report to the firm's money laundering reporting officer or nominated officer, who in turn may make a suspicious activity report to the National Crime Agency. If proceeding with the transaction would otherwise involve a money laundering offence, the firm may seek defence against money laundering by requesting consent from the NCA to continue. During this period, the solicitor often has to delay or pause the transaction without being able to tell the client why.
This constraint links to another offence, tipping off under Section 333A. It is an offence to tell the client or a third party that a suspicious activity report has been made or that an investigation is underway, where that disclosure is likely to prejudice the investigation. This can create acute ethical tension. A solicitor may be required to delay completing a purchase or transfer or to refuse to act further, but cannot reveal that the true reason relates to a money laundering report. They must instead give a neutral explanation that does not expose the existence of the SAR. If POCA creates the criminal offences, the Money Laundering Regulations 2017, as amended, create the preventative framework. They require firms to put in place risk-based systems and controls to manage the risk of being used to launder money. Central to this is customer due diligence. Before establishing a business relationship or carrying out certain transactions, a firm must identify the client and verify their identity using reliable independent sources. Where the client is a company or other entity, the firm must identify and verify the beneficial owner, the individuals who ultimately own or control the entity. Modern best practice extends CDD beyond simple identity checking. Firms are expected to understand the purpose and intended nature of the business relationship, the source of funds for the particular transaction, and, where appropriate, the client's broader source of wealth. In higher risk situations, the regulations require enhanced due diligence. This includes transactions involving politically exposed persons, clients resident in high-risk third countries, or situations where the ownership structures are especially complex with no clear commercial rationale. The list of high-risk jurisdictions is updated periodically. In late 2024 and into 2025, the UK adjusted its list, for example removing South Africa and Burkina Faso, while maintaining or adding others such as Kenya and Bulgaria. For solicitors in practice, this means that they cannot rely on old assumptions. They must check the current list each time they encounter a relevant jurisdiction. The designation of a country as high risk automatically triggers additional checks and scrutiny. The SRA has also identified emerging and now mainstream risks in its AML guidance. Capital flight from high-risk states, misuse of pooled client accounts to disguise beneficial ownership, and sophisticated forms of vendor fraud in property transactions are no longer exotic. They are part of the expected risk landscape. Firms are expected to have documented risk assessments and tailored controls to deal with these issues, not generic policies copied from templates. Overlaying this existing framework is the new corporate offence of failure to prevent fraud under the Economic Crime and Corporate Transparency Act 2023. This offence came into force on 1 September 2025 and marks a major shift in corporate criminal liability for large organisations, including many law firms. It applies to organisations that meet at least 2 out of 3 thresholds relating to employee numbers, turnover and balance sheet totals. Many large firms clearly satisfy these tests. Under the failure to prevent fraud offence, an organisation is automatically guilty if an associated person such as an employee, agent or subsidiary commits a specified fraud offence intending to benefit the organisation or its clients. Crucially, prosecutors do not need to show that senior management knew about or approved the conduct. The only defence available is to show that at the time of the fraud the organisation had reasonable procedures in place to prevent such offences, or that it was reasonable not to have such procedures. As a result, firms have been forced to look beyond AML controls and consider fraud risk in a broader sense. They must assess the risk of internal fraud by staff, frauds facilitated by poor supervision, and external frauds in which the firm might be used as an unwitting channel. Policies, chaining whistle-blowing mechanisms, and monitoring systems all have to be updated, and because the offence has extraterritorial reach, international firms need to consider behaviour in all their offices where there is a UK nexus.
Solicitors and financial services. The regulatory picture becomes even more intricate when one considers financial services law. Clients often turn to solicitors for advice around major financial decisions, mortgages, investments, insurance, settlement structures. However, most aspects of financial services are regulated by the Financial Conduct Authority under the Financial Services and Markets Act 2000. Section 19 of that Act imposes the general prohibition: no one may carry on a regulated activity in relation to a specified investment in the United Kingdom unless authorized or exempt. Breach is a criminal offence and can render agreements unenforceable. Specified investments include things like shares, bonds, units in collective investment schemes, contracts of insurance, and regulated mortgage contracts. Regulated activities include dealing in investments, arranging deals, advising on investments, and managing investments. At first glance, that would suggest that many everyday activities of solicitors, such as recommending a particular indemnity insurance policy or suggesting that a client should accept shares rather than cash, might require FCA authorization. In practice, most firms rely on the exempt professional firms regime in Part 20 of FSMA. Under Section 377 and related provisions, firms authorized by a designated professional body such as the SRA can carry on certain regulated activities without FCA authorization, provided they meet the conditions of what is commonly called the incidental test. The incidental test requires, in essence, that the financial services activity be probably incidental to the provision of professional legal services, that the firm does not market itself as providing regulated investment services in its own right, and that any commissions or benefits received from third parties are handled in accordance with SRA rules, including clear disclosure and accounting to the client where appropriate. For example, arranging a defective title indemnity insurance policy as part of a conveyancing transaction is incidental. Running a side business selling life insurance policies to anyone who walks in off the street is not. Firms that wish to operate beyond the incidental scope generally need to obtain FCA authorization or to work closely with an authorized intermediary. Insurance distribution has its own additional regulatory layer following the implementation of the Insurance Distribution Directive. Even when relying on the Part 20 exemption, firms involved in arranging or advising on insurance products must appear on the FCA's exempt professional firms register as undertaking insurance distribution. They must appoint someone, sometimes called an insurance distribution officer, to oversee compliance. When arranging products such as after-the-event insurance with litigation, solicitors must assess the client's demands and needs and ensure that the recommended product meets those demands and needs. The SRI Financial Services Scope Rules make it clear that firms may not undertake insurance distribution activities at all unless they have notified the SRA and appear on the relevant register. Development in the financial services world also affect expectations of solicitors around client care. The introduction of the Consumer Duty and FCA regulation, which requires firms to act to deliver good outcomes for retail customers, has influenced how the SRA frames its own rules on information and costs. The SRA codes require solicitors to give clients information in a way they can understand and to make sure clients are genuinely in a position to make informed decisions about services and pricing. This goes beyond merely handing over a long, fine-print client care letter. The obligation is to communicate in a way that works for that particular client, including those who are vulnerable or have low financial literacy, and to ensure that the fees charged represent fair value compared to the benefits delivered.
Funding legal services. The question of how legal services are funded is both a regulatory and a practical issue. Understanding funding mechanisms is essential for SQE because advising on costs and funding options is part of what a competent solicitor is expected to do. The current landscape is a patchwork of private fees, risk-sharing arrangements, and a significantly reduced legal aid system. Conditional fee agreements are one of the key risk-sharing mechanisms in civil litigation. In a typical no-win, no-fee agreement, the solicitor agrees that if the case is lost, the client will not have to pay the solicitor's basic fees, though they may still be liable for disbursements and potentially some of the opponent's costs if those are not otherwise insured. If the case is successful, the client pays the basic costs plus a success fee, which is an agreed uplift. Since the reforms under the Legal Aid Sentencing and Punishment of Offenders Act 2012, success fees are usually not recoverable from the losing party and must be paid out of the client's damages. To prevent exploitation in personal injury cases, the success fee is capped at 25% of the combined total of general damages for pain, suffering, and loss of amenity, and damages for past financial loss. Damages for future losses are protected and cannot be eaten into by the success fee. The cap includes VAT. Solicitors must give clear explanations of the effect of these arrangements so that clients understand that no win, no fee does not mean no cost risk of any kind. Damages-based agreements are an alternative model. Under a DBA, the solicitor's payment is a straightforward percentage of the client's damages, subject to statutory caps of 25% in personal injury, 35% in employment tribunal matters, and 50% in other kinds of civil litigation. Unlike a CFA, the DBA fee is not an uplift on time-costed work, it is the whole fee structure. The DBA regulations 2013 have turned out to be extremely technical and unforgiving. In 2025, the decision in Reeves v. Frayne and McKinnon of the Senior Courts Costs Office underline this. In that case, solicitors had entered into high-value DBAs in a probate dispute over an estate worth around £100 million. They attempted hybrid structures in which they charged some conventional fees alongside the contingency element. The court held that these models were inconsistent with the regulations and therefore unenforceable. The result was that the solicitors could not recover millions of pounds in fees for years of work undertaken under those arrangements. For a would-be SQE solicitor, the lesson is stark. If a DBA does not comply strictly with the regulations, the firm may not get paid at all. Third-party funding adds another layer to the funding landscape. In these arrangements, an external commercial funder agrees to cover some of the client's legal costs in return for, typically, a percentage of any damages recovered. If the case fails, the funder loses its investment and may, depending on the terms, cover adverse costs or some of them. A Supreme Court's decision in Pakar in 2023 transformed this market by holding that certain litigation funding agreements were in fact DBAs and therefore unenforceable if they did not comply with the DBA regulations. This caused significant uncertainty. Later legislation has partly addressed the position for collective competition proceedings, but outside that sphere the market remains cautious. Solicitors advising clients on third-party funding must explain not only the headline funding figure, but also the likely percentage deductions from any recovery and the risk that the agreement might prove unenforceable.
The shrinking scope of state-funded assistance through legal aid is another critical feature. Civil legal aid is administered by the Legal Aid Agency and is available only in limited categories of case, principally asylum, certain immigration matters, domestic abuse cases with evidence, public family law proceedings such as care orders, mental health tribunals, and some housing matters involving homelessness or serious disrepair. Even where the type of case is in scope, the client must pass both a merits test and a means test. As of 2025, the financial thresholds are relatively stringent. There are upper limits on gross monthly income, on disposable income, and on capital. Some applicants receiving certain passporting benefits automatically satisfy the income test, but capital may still disqualify them. The government has acknowledged that these thresholds have been eroded by inflation and promised a means test review to update them. However, implementation of the review has been delayed until 2026, leaving the restrictive 2024 and 2025 thresholds in place. For SQE candidates, that means they must work with the current regime, not the promised future one. Criminal legal aid operates differently. At the police station stage, advice and assistance are available free for all detainees and volunteers regardless of means. For representation in the magistrate's court, the defendant must satisfy both an interests of justice test, often framed through the Widgery criteria, which consider factors such as risk of imprisonment, complexity, and ability to self-represent, and a means test. In the Crown Court, legal aid is in principle available where the interest of justice test is met, but applicants with higher incomes may have to pay contributions, and there is an upper threshold beyond which defendants are expected to fund their defence privately. The means assessment is detailed, involving deductions for tax, national insurance, housing costs, childcare, and a fixed cost of living allowance from gross income in order to arrive at a disposable income figure. Another aspect of public protection is professional indemnity insurance. The SRA's indemnity insurance rules require all authorised firms to carry insurance that complies with the minimum terms and conditions. For incorporated firms and LLPs, the minimum level of cover per claim is generally £3 million. For sole practitioners and traditional partnerships, the minimum is typically £2 million. The policy must cover civil liability arising from private legal practice, usually including negligence, breach of trust, and certain other heads of claim. It will not cover criminal fines or most regulatory penalties, but it does often cover defence costs in civil claims and some regulatory investigations. A crucial feature is the requirement for run-off cover. If a firm closes, its last insurer must provide 6 years of cover for claims arising from work done before closure, even though no new premiums are being paid. This ensures that clients who discover negligence years later are not left without a solvent defendant.
In conclusion, the regulation of legal services in England and Wales is a web of interconnected obligations and consequences. A failure to carry out adequate money laundering checks is not just a procedural lapse, it may be a criminal offence under the Proceeds of Crime Act, a regulatory breach attracting unlimited fines, and a failure of competence under the Statement of Solicitor Competence. Misunderstanding the damages-based agreements regulations can convert a spectacular courtroom victory into an economic disaster for the firm, as seen in recent case law. Overlooking the boundary between unreserved legal work and reserved activities can lead to criminal liability for unauthorized practice. Blurring the line between legal advice and investment advice can breach the general prohibition under FSMA. For the aspiring solicitor, success in the SQE requires more than memorizing lists of rules. It requires an appreciation of the hierarchy of duties, where the rule of law and the administration of justice sit above client preference and commercial convenience. It calls for the ability to spot the invisible lines, the point at which a paralegal's work amounts to the conduct of litigation, the moment when a casual discussion about insurance becomes a regulated financial services activity, and the telltale signs that a client's apparently smart business deal may actually be an attempt to launder criminal funds. As the profession moves through 2025 and towards 2026, the regulatory grip is tightening, particularly around economic crime and fraud. The new failure to prevent fraud offence and the tougher stance on sanctions compliance highlight that the modern solicitor is expected to function not only as a legal advisor, but also as a risk manager and compliance gatekeeper. Mastering this web of regulation is not simply a way to collect marks in FLK1. It is an essential part of surviving and maintaining integrity in contemporary legal practice.
In England and Wales, every legal dispute is a story waiting for an ending. Some stories end quietly at a mediation table, others play out behind closed doors in arbitration, and a few march all the way to the courtroom. This video is your complete guide to dispute resolution for SQE1. Dr. Yannis will walk you through every step from those first client conversations and pre-action protocols to the moment judgment is enforced. You'll learn how to decide whether arbitration, mediation, or litigation is the right battlefield, how limitation and applicable law shape a claim before it even begins, and how to draft, serve, and defend proceedings the right way. We follow the SRA specification for FLK Dispute Resolution. We'll unpack statements of case, interim applications, case management, disclosure, evidence, trial, costs, appeals, and enforcement. We look at 10 key areas covering everything the examiner expects and everything a newly qualified solicitor must master in practice. So if you're preparing for the SQE1 FLK Dispute Resolution, stay tuned. By the end of this video, you won't just know the rules, you'll understand how to use them. 1. Analysis of merits of claim or defense. When a client arrives with a dispute, the first task is to test the problem against causes of action and defenses that the courts will recognize, and to decide what can actually be proved on the balance of probabilities. That means identifying the essential elements of the claim or defense, mapping each element to concrete evidence you already have or can realistically obtain, and stress testing limitation, parties, forum, and applicable law before you talk about remedies. Keep the distinction clear between grievances and courses of action. A missed delivery date is not actionable without a contractual term or duty. A reputational slight becomes defamation only if it satisfies publication, reference, and serious harm. From the defense side, you interrogate the same elements in reverse. Is there a break in causation, a failure of proof on loss, or a complete answer such as limitation or illegality? And you keep one eye on enforcement from day one. A claim that is technically sound but aimed at a defendant with no accessible assets may not be in the client's interests because cost risk sits behind every step in English litigation. The SQE specification expects you to analyse all of this at the level of a newly qualified solicitor. Elements, evidence, limitation, jurisdiction and enforcement, not just legal labels. You then build an evidence-led merits memo. Relevance is your compass and weight your destination. Ask what the judge needs to decide and whether each proposed fact helps or hinders that decision. The standard of proof in civil cases is the balance of probabilities. Serious allegations still use that standard, but the court expects cogent evidence commensurate with the gravity of what is alleged. Documentary sources, witness memory, expert input and real evidence are all filtered through proportionality. Will this step move the needle enough to justify the cost and time? The court can exclude even relevant material if admitting it would not assist just resolution at proportionate cost. That is why you plan early. Preserve documents, line up witnesses while memories are fresh, and decide whether an expert is really needed or whether the issue is legal rather than technical. If the case relies on the other side's records, consider pre-action disclosure to crystallize strengths and weaknesses before issue. 2. Arbitration, mediation, and litigation as an appropriate mechanism to resolve a dispute. Choosing the right path is strategic. Litigation offers a public forum, precedent, strong coercive powers against parties and non-parties, and a full appellate structure. It can also be slow, expensive, and relationship damaging. Mediation and other consensual processes prioritize speed, confidentiality, creative outcomes, and relationship preservation. They are ideal when parties want control over both process and outcome. Adjudication in certain sectors, such as construction or consumer schemes, delivers a swift decision that keeps money flowing, with scope to revisit later. Arbitration, while sometimes discussed separately from ADR in England and Wales, is the private adjudicative alternative to court.
party-chosen procedure and decision-maker, final binding award, limited grounds of challenge, and powerful domestic and international enforcement under statute and the New York Convention. The right choice turns on what the client values: confidentiality, specialist decision-makers, enforceability abroad, or the need for precedent and court powers over third parties.
Since the Court of Appeal's decision in Churchill v. Merthyr Tydfil County Borough Council, the courts can lawfully stay proceedings or order engagement in non-court dispute resolution where doing so pursues a legitimate aim and is proportionate to the party's Article 6 right to a fair trial. CPR amendments in force from 1 October 2024 embed this approach. Judges must now consider whether to order or encourage ADR when giving directions, and unreasonable refusal can sound in costs. In practical terms, you should advise clients that ADR is not a box tick, but a core step that can be compelled and that will affect the wallet. Record good faith offers to mediate, propose realistic models and timing, and use ADR to refine issues, even if settlement is unlikely. Arbitration has also been modernised. The Arbitration Act 2025 refines the 1996 framework by codifying the arbitrator's duty of disclosure following Halliburton v. Chubb, strengthening summary disposal, clarifying the approach to jurisdiction challenges and emergency relief, and adjusting aspects of arbitrator immunity and the law applicable to the arbitration agreement. None of this alters the essentials. Consent, neutrality, confidentiality, finality, and enforceability remain the selling points. For cross-border counties, these refinements make London arbitration an even cleaner choice when privacy, expertise, and international enforcement are critical.
3. Pre-action considerations and steps. Before you issue, you evaluate limitation meticulously, identify the correct parties and causes of action, and engage with the applicable pre-action protocol, or, where none applies, the practice direction on pre-action conduct and protocols. The objectives are consistent. Exchange sufficient information to understand each other's positions. Make reasonable requests for key documents. Explore settlement, including ADR, and keep the process proportionate. Courts expect compliance and can impose costs or other sanctions for unreasonable failures even on a party who later wins a trial. Where time is tight because of limitation, you can protect the position by issuing and then proposing a standstill on service to allow protocol-compliant engagement. But do not leave service to the last moment without good reason, because validity windows are strict. Remember that Welsh language rights apply in civil proceedings issued in Wales. Plan for language requirements from the outset. Use the pre-action phase to shape merits, identify what you must prove and what the other side must prove. Ask for the documents that matter, consider a targeted expert scoping letter, and table a realistic ADL proposal with timing that fits the evidence timetable. If you need pre-action disclosure to do justice or save costs, apply early. If enforcement will later matter, discreetly check asset positions and insurance. Clients should understand that sensible pre-action work is an investment. It narrows issues, avoids ambush, and often pays for itself in settlement savings.
4. Commencing, responding to, or progressing a claim. Proceedings begin with claim form, followed by particulars of claim if not served with it. Draft concisely but with enough detail to show the legal basis and factual core. For defendants, acknowledgement and defences run on tight timetables. A defence must engage each allegation with admission, denial and reasons, or non-admission with reasons, and raise any positive case and any counterclaim. Jurisdiction challenges must be taken promptly and in the prescribed way. If the defendant does nothing, the claimant can seek default judgment. Setting it aside later hinges on promptness and a real prospect of success. Discontinuant, Tomlin orders, and Part 56 offers are all procedural tools for ending or reshaping litigation in a controlled way. The theme across all of this is discipline, pleadings that define issues, service that complies with the rules, and proactive management of deadlines. Service is jurisdictional. Within England and Wales, follow approved methods and note deemed service dates. The claim form is valid for service for 4 months from issue. Let that expire without good reason, and you may face strikeout. For service out of the jurisdiction, decide whether permission is required, identify a gateway, address forum convenience, and use an appropriate method under the foreign state's rules or applicable convention. Where orthodox service is impracticable, seek alternative service with evidence of diligent attempts and a proposal that is likely to bring the documents to the defendant's attention. Electronic service requires consent or court order. Don't assume an email address on a letterhead is consent for CPR service.
5. Case management and any interim applications relevant to a claim. After statements of case close, the court allocates to a track. Today there are 4: small claims for the lowest value disputes, fast track for straightforward cases typically listed for a one-day trial, the intermediate track introduced with the extended fixed recoverable costs regime for simpler mid-value cases up to around £100,000, and the multi-track for complex or higher value litigation. With allocation comes a directions timetable covering disclosure, witness statements, experts, and trial windows. The court's case management powers are exercised to further the overriding objective, which now sits alongside an explicit policy of encouraging or ordering ADR where appropriate. Non-compliance attracts sanctions, and relief from sanctions depends on seriousness, promptness, and the overall justice of the case. Interim applications are part of the court's toolkit to keep cases fair and efficient. Summary judgment is available where a claim or defense has no real prospect of success and there is no other compelling reason for a trial. It requires focused evidence and careful calibration of what is law and what is disputed fact. Interim payments deliver part of a likely monetary judgment early where liability is strong. They require robust evidence on liability and quantum. Interim injunctions preserve the status quo where there is a serious issue to be tried. Damages would be inadequate, and the balance of convenience favours restraint, backed by a claimant's undertaking in damages. The evidence for injunctions must be full and fair, especially without notice. Directions hearings routinely consider whether to order or encourage ADR. Courts now treat ADR as a mainstream case management step, not a side road.
6. The evidence needed and disclosure steps required in commencing, responding to, progressing, or defending a claim. Evidence should track the issues, start with what must be proved and by whom. The legal burden aligns with the party making the assertion. The evidential burden is the practical obligation to adduce enough material to put the point in play. The standard remains the balance of probabilities, even for serious allegations, but courts expect stronger, more cogent material where allegations are grave. Relevance admits evidence, weight determines its impact. Judges actively manage evidence to avoid cost and delay. This means narrowing issues early, confining expert questions to what truly needs expert input, and focusing witness statement on first-hand facts rather than commentary or argument. Disclosure is proportional. Standard disclosure requires each party to disclose documents on which it relies that adversely affect its case or another party's case, or that support another party's case, including electronic material. Directions may adopt different disclosure models to scale effort to the dispute. Privilege protects legal advice, litigation preparation, and without prejudice communications. Waive privilege only deliberately and with a plan. Pre-action disclosure can save costs and clarify merits, and non-party disclosure is available where necessary and proportionate. Hearsay in civil proceedings is admissible under the Civil Evidence Act 1995, but you should still consider fairness and reliability and serve notices where appropriate. Hearsay's weight depends on circumstances, such as the ability to call the maker and the quality of the record. If disclosure fights arise, applications for specific disclosure must be targeted, showing that the classes sought are likely to exist and are proportionate to the issues and sums at stake. Witness statements must be in the approved form, containing only what the witness could say orally, and be verified by a statement of truth. Their purpose is to replace evidence in chief, so that trial times is used for cross-examination and submissions. When memory is at risk, refresh with contemporaneous documents in accordance with the rules and guidance. Experts are permitted by court order under CPR Part 35, owe duties to the court, and must be impartial. Courts increasingly use single joint experts in proportionate cases and may ask experts to meet and produce a joint statement of matters agreed and not agreed. Ethical constraints are strict. Solicitors do not shape testimony, they prepare witnesses to tell the truth clearly. Experts must stay within their expertise and explain their methodology and data so the court can test reliability.
7. Preparation of a case for trial, the trial and any post-trial steps. Preparation accelerates as trial approaches. You complete pre-trial checklist confirming readiness, crystallizing outstanding applications, fixing time estimates, interpreters, and any special measures. The claimant prepares a trial bundle that is paginated, indexed, and compliant with directions, ideally agreed to avoid duplication. Skeleton arguments help the judge navigate the issues quickly and anchor oral submissions. A trial evidence-in-chief is usually by witness statement. Cross-examination tests reliability and credibility. Re-examination clarifies it does not repeat. Experts may give concurrent evidence if ordered, focusing on the true points of difference. Courtroom etiquette matters because it supports clarity, modes of address, when to rise, how to handle objections, and how to pace submissions, so the judge can follow the logic. Judgment may be given immediately or reserved. Orders follow, dealing with remedies, interest, costs, and compliance deadlines. You must then switch quickly to consequential matters. If money is due, consider time to pay or immediate enforcement. If an injunction was granted, advise meticulously on the terms to avoid contempt. If specific performance was ordered, calendar the steps and monitor them. Keep settlement in view even at the door of the court. Part 23 and other structured offers can resolve disputes late with clear cost consequences, and courts continue to encourage mediation at every stage. If appealable errors are apparent, move fast on permission and stays. Appeals are not reruns, but focused challenges to error.
8. Procedures and processes relevant to costs involved in dispute resolution. Costs discipline starts at day 0. Budget the case if budgeting applies, file on time, and keep budgets realistic. The expanded fixed recoverable costs regime now covers the fast track and the newer intermediate track, calibrating what can be recovered to the work band and complexity. This should shape litigation tactics from pleadings to experts. Inter-parties costs are usually awarded to the winner, but the court's discretion is wide and conduct matters. Pre-action compliance, compliance with directions, and a party's approach to ADR all influence outcomes. On assessment, standard basis allows only reasonable and proportionate costs, with doubt resolved in favour of the paying party. Indemnity basis is available where conduct justifies it and reverses that doubt. Security for costs protects defendants facing impecunious claimants. Non-party costs orders remain available against funders or others who control litigation. Part 36 is a powerful lever. Beating your own Part 36 can unlock enhanced interest and cost uplifts, while failing to beat the opponent's offer can be painful. Recent adjustments align Part 36 with the fixed recoverable costs landscape and track structures introduced in October 2023 and refined in 2024. Courts will also now readily reflect unreasonable refusal to mediate in costs following Churchill and the 2024 CPR changes.
9. Appeals. An appeal challenges error, not outcomes you dislike. Identify the right appellate route and the need for permission. Grounds must show an error of law, a wrong exercise of discretion, or a plainly wrong evaluative conclusion. A mere disagreement with findings of primary fact rarely succeeds. Time limits are tight. Preserve your position immediately after judgment by indicating an intention to appeal if appropriate and seeking a short stay only where merits and prejudice justify it. Skeleton arguments must be disciplined and cross-referenced to a lean, accurate bundle. In arbitration, routes are narrower because finality is a core feature. Post-2025 changes clarify how Section 67 jurisdiction challenges are run and tighten aspects of appealability, while serious irregularity remains a high bar.
10. Enforcement of money judgments. Enforcement strategy is asset-led. If the debtor has goods, writs or warrants of control allow enforcement officers to seize and sell. If there is steady income, consider an attachment of earnings. If money sits with a bank or a trading counterparty, a third-party debt order can intercept it. If there is land, a charging order secures the debt, and an order for sale may follow if proportionate. Orders to obtain information can compel the debtor to attend court to answer on oath about assets. Evasiveness risks contempt. For specific performance or injunctions, committal powers back the order. Each route has cost, speed, and impact profiles. Select the one that matches the debtor's footprint and the client's risk appetite, and avoid spend that outstrips recovery. Where a foreign award or judgment is involved, consider recognition routes, New York Convention for Arbitrary Awards, common law or statutory schemes for foreign judgments. Build enforcement planning into the case from the start. It guides offers, timelines, and the choice between litigation, ADR, and arbitration.
Additional integrations the SR expects across topics: parties, causes of action, applicable law, and specialist courts. Across every stage, you must be precise about parties. Identify the real contracting entity, successors, assignees, insurers, and necessary co-defendants early, because late joinder can collide with limitation. In cross-border disputes, Rome 1 and Rome 2 can point you to a foreign law that must be pleaded and proved as fact. Factor that into cost and expert planning. Choose the right forum: counter court for most straightforward disputes, high court divisions for complex or higher value business, and specialist lists such as the commercial court or the technology and construction court when their procedures and expertise add value. If proceedings are in Wales, plan for Welsh language rights from the start so hearings, documents, and interpretation are set up properly. Bringing it together for SQE1 candidates. The way to excel in dispute resolution is to treat the syllabus as the logic of practice. Start with merits you can prove and a remedy you can enforce. Use the pre-action stage to narrow issues and set up ADR. Choose litigation, mediation, or arbitration for reasons tied to your client's goals. Plead with discipline, serve correctly, and take case management seriously. Build an evidence plan that matches the issues and the proportionality lens. Prepare for trial like an editor, not a hoarder. Budget, use Part 36 intelligently, and manage costs and risks from the outset. When judgment comes, move directly to compliance or enforcement and appeal only where genuine error can be shown. That is the modern English model, fair, efficient, proportionate, and now explicitly ADR forward, and it is the model the SRA expects you to demonstrate in the exam and in practice.
The solicitor didn't steal. No client complained. No one lost any money, and he was still struck off. Because under the Solicitors Accounts rules, intent does not matter. If a solicitor uses client money temporarily to keep his firm going, even if he plans to replace it, even if he sees it as short-term cash flow, the SRA sees something else. Client money is not your piggy bank. The moment you treat it as your own, even briefly, integrity is lost.
In this lecture, prepared by Dr. Yannis, we are going to explore in detail how the SRA accounts rules operate, what they require of authorized firms and individuals, why they are enforced the way they are, and how anti-money laundering obligations intersect with the handling of client money. This is not just about technical accounting, it is about professional conduct, public protection, and the very foundations of trust on which legal practice in England and Wales depends. Client money, public confidence, and regulatory context. To understand the regulatory landscape governing solicitor accounts in England and Wales, it is necessary to recognise the dual purpose of the SRA accounts rules, protecting clients' funds and maintaining public confidence in the legal profession. The SRA's accounts rules are not optional guidance, they are regulatory requirements that apply mandatorily to all firms and individuals authorised by the SRA. These rules govern every stage of dealing with client money, from receipt, record-keeping and reconciliation, through to withdrawal, return and reporting. At their core is a principle that client funds must be protected, segregated and appropriately administered. The regulatory environment in 2026 is defined by a significant paradigm shift in supervision and enforcement precipitated largely by the catastrophic collapse of Axiom Inc. in late 2023. Which resulted in a client money shortfall of approximately £60 million. This event, along with the failures of other accumulative firms like the SSB Group, exposed systemic vulnerabilities in the SRA's risk detection capabilities and led to a rigorous intervention by the Legal Services Board. These obligations sit alongside and interact with the SRA's anti-money laundering framework. Firms must design and implement systems that not only comply with the accounts rules themselves, but also address wider financial crime risks. The result is a regulatory regime in which the handling of client money is both a technical accounting exercise and an ethical duty aligned with professional conduct expectations. This report explains these rules in detail, covering key definitions, operational requirements, statutory expectations, AML linkages, enforcement approaches, and common compliance challenges. It reflects both the current regulatory text and the interpretation and enforcement context in 2026.
The post-Axiom Inc. regulatory landscape. The aftermath of the Axiom Inc. intervention has fundamentally altered the SRA's approach to client money. Following an independent review commissioned by the LSB, the regulator was issued binding directions to strengthen its oversight mechanisms. The review highlighted that the SRA had failed to act adequately or effectively in identifying risks posed by firms growing rapidly through mergers, accumulator firms, and those where compliance roles, COLP or COFA, were concentrated in a single individual. In response, the SRA's 2025-2026 business plan prioritizes the protection of client money through several key initiatives. Enhanced monitoring, the use of sophisticated data analytics to identify irregular financial patterns, such as unusual fluctuations in client account balances or rapid increases in turnover that do not match the firm's profile. Stricter accountants reports. Proposals introduced in late 2025 aim to require all firms, not just those with qualified reports, to submit their annual accountants reports to the SRA. This allows for a comprehensive market-wide view of compliance. Consumer Protection Review.
A broad review of the consumer protection framework is underway, examining whether the model of solicitors holding client money remains viable in the long term or whether alternatives like third-party managed accounts, TPMAs, should become mandatory for high-risk transactions. For candidates preparing for the SQE, understanding this context is vital. Exam scenarios may test not just the mechanics of the rules, but the risk implications of non-compliance. A failure to reconcile accounts is no longer just a breach of Rule 8.3, it is a red flag for potential insolvency or theft that triggers immediate regulatory escalation.
Who must comply and what client money means? The SRA accounts rules apply to all authorised firms and individuals regulated by the SRA, including sole traders, partnerships, incorporated practices, LLPs and limited companies, and alternative business structures, ABS. These rules operate across a variety of contexts and require firms to implement systems and controls appropriate to the volume and nature of client money handled. The regulatory design recognizes that the scale of client transactions may vary, but the obligation to protect client funds remains consistent. The definition of client money, Rule 2.1. Under Rule 2.1 of the SRA Accounts Rules, client money refers to any money received or held by a firm in connection with regulated legal services that is not yet due to be transferred to a third party or paid as fees following billing. Specifically, client money is money held or received, 1. relating to regulated services, money held for a client in the course of providing legal advice or representation, 2. on behalf of a third party, funds held as an agent, stakeholder, or to the sender's order in connection with regulated services, 3. as a trustee or office holder, money held where the solicitor acts as a trustee, court of protection deputy, or donee of a power of attorney, 4. in respect of fees and unpaid disbursements. Crucially, this includes money received for fees and disbursements prior to the delivery of a bill or written notification of costs. This fourth category is a common area of confusion. Money received on account of costs is client money because the firm has not yet earned it by delivering the service and issuing a bill. It must be held in the client account. It only becomes business money, funds belonging to the firm, once a bill has been validly delivered to the client and the specific sum identified in the bill is transferred. Distinguishing client money from business money. It is crucial to note that not all money received by a firm is automatically client money. For example, funds that are clearly attributable to the firm's business income, once properly billed and due, are not treated as client money. Reimbursements. If a firm has already paid a disbursement, aka a search fee, using its own business funds, any money received from the client to reimburse that specific expense is business money. Agreed fees. Historically, agreed fees could be paid into the office account. Under the 2019 rules as applied in 2026, money for fixed fees is generally client money until the work is done and a bill is sent. However, Rule 2.1d creates a nuance. If a bill is delivered before the money is received, the receipt can be treated as business money. The SRA guidance on taking money for your firm's costs clarifies that firms can bill for work not yet done, aka an agreed fixed fee, and pay this into the business account, provided the client is informed and the risks are managed. However, if there is any doubt whether money belongs to a client or to the firm, the regulator expects firms to treat it as conservatively client money until it can be properly allocated. This ensures the protective purposes of the regulatory framework.
Third-party managed accounts, TPMAs. Client money also includes money held in more complex arrangements, such as third-party managed accounts, TPMAs, provided that the firm controls or manages the handling of those funds in the context of delivering regulated services. Rule 11 allows firms to use a TPMA as an alternative to holding client money directly. Requirements. The TPMA provider must be regulated by the Financial Conduct Authority, FCA. The firm must inform the client of the arrangement, including who pays the fees and the client's right to terminate. Regulatory status. Funds in a TPMA are not held by the solicitor, so they do not fall under the SRA's compensation fund in the same way as money in a client account. Solicitors must ensure clients understand this distinction. Adoption. While adoption was initially slow, the SRA's 2025-26 consultations have actively encouraged TPMAs as a mechanism to de-risk the profession, reducing the temptation for dishonesty and the burden of holding millions in client funds. Client accounts and segregation of funds. Once money is determined to be client money, the accounts rules require it to be held in a designated client account, a bank or building society account in the name of the firm that clearly identifies it as a client account. The account must be held at a branch or head office in England and Wales. The principle of segregation. The account must be separate from the firm's own business or office account. This segregation is fundamental. It protects client funds from being mistaken for business funds, from being misused for purposes unrelated to the client, and from being caught up in insolvency processes affecting the firm. Insolvency protection. In the event of a law firm's failure, like Axiom Incy, funds in a properly designated client account are deemed to be held on trust. They do not form part of the firm's assets available to general creditors. If funds are improperly mixed in a business account, this protection is compromised, potentially leading to total loss for the client. Duty to monitor. Firms must monitor where their client accounts are held and take steps to ensure the institutions are financially sound and appropriately regulated. Prohibition on banking facilities. Rule 3.3. The segregation requirement is not merely procedural, it reflects the regulator's prioritization of trust and confidence. If firms commingle client money with business money, they erode that trust and create significant risk. For that reason, and because of associated money laundering concerns, the accounts rules prohibit firms from using their client account as a general banking facility for clients or third parties. Rule 3.3 states you must not use a client account to provide banking facilities to clients or third parties. Payments into and transfers or withdrawals from a client account must be in respect of the delivery by you of regulated services. This rule is a critical enforcement priority. The SRA has issued multiple warning notices emphasizing that the client account is not a bank account for the convenience of wealthy clients or corporations. The proper connection test. There must be a clear nexus between the money held and a specific legal transaction. For example, holding £1 million for a client pending investment opportunities without a specific property purchase or commercial deal in progress is a breach. Case law. SRA versus Clyde & Co. 2017. The firm was fined £50,000, which was a record at the time, for allowing its client account to be used as a banking facility for clients who struggled to open UK bank accounts. The tribunal ruled that acting as an escrow agent in isolation without underlying legal work breached the rule. Case law, SRA versus Mishcon Dereya 2022. The firm was fined £232,500 for AML and banking facility breaches. It facilitated transactions where the legal work was minimal or non-existent compared to the volume of funds moved, effectively acting as a bank. A client account is not a deposit account for speculative or wide-ranging financial purposes. It must be used strictly in connection with the delivery of regulated legal services and only for the specific clients or third parties for whom the money is held. Funds held in these accounts must be traceable, reconcilable, and capable of being returned without unnecessary delay when the money is no longer required for its original purpose.
Receipt of client money and prompt payment. Under the accounts rules, when client money is received by a firm, it must be paid into the client account promptly, while the 2011 rules specified without delay, often interpreted as the next working day. The 2019 rules, applicable in 2026, use the term promptly, placing the onus on the firm to justify any delay. Operational expectations. Although the rules do not prescribe an exact number of days, the expectation in practice is that firms develop internal policies that minimize delay, such as ensuring client monies, whether received by check, electronic transfer, or cash, are deposited into the client account within 1 to 2 business days. Risk of delay. This prompt payment requirement helps to avoid situations where client funds remain in a business account or other non-segregated account for extended periods, which could lead to misappropriation, confusion in records, or regulatory breaches. Checks. Checks should be banked immediately. Holding a check on a file for weeks until the deal completes is a breach of the obligation to safeguard client assets. Handling mixed payments. Rule 4.2.
The SRA recognises that firms may receive mixed payments, that is, payments that include both client money and firm money in a single transaction. For example, a client pays a comprehensive sum of £5,000, comprising £3,000 for a settlement, client money, and £2,000 for professional fees, business money. In such cases, the firm must allocate funds promptly and correctly between the client account and the firm's business account. Best practice, the standard approach is to pay the entire mixed sum into the client account. Once the funds have cleared, the business money portion, £2,000 in the example, must be transferred out to the business account promptly, typically within 14 days. Alternative, firms may pay the mixed sum into the business account, but must then transfer the client money portion to the client account immediately. This approach carries higher risk if the firm's business account is overdrawn or frozen. If a firm receives money that is not genuinely client money, such as funds clearly attributable to third parties unrelated to regulated services, it should not be paid into a client account. Mistakes in allocation can lead to regulatory breaches and may undermine compliance with both the accounts rules and AML requirements. Note that a 14-day window for transferring business money out was a hard rule in 2011. Under the 2019 rules, now the requirement is simply promptly. Most firms still use 14 days as a safe harbour, but the SQE may use the word promptly in its correct answer options.
Withdrawal of client money and notification of costs. One of the most critical aspects of the accounts rules is the requirement governing withdrawals from client accounts. Client money may only be withdrawn in specified circumstances, and even then strict procedural requirements must be observed. Permitted withdrawals, Rule 5.1. Under the accounts rules, client money may be withdrawn from a client account where it is 1. Used for the purpose for which it is held, e.g., paying stamp duty, a settlement sum or a beneficiary, 2. Following the client's instruction, 3. On the SRA's prior written authorization or in prescribed circumstances, such as a court order. Note that when needed, reasonable steps to trace a client include at least one letter to the last known address and potentially an electronic search even for amounts under £500. The sufficient funds requirement, Rule 5.3. Rule 5.3 contains a fundamental prohibition. A firm must not withdraw client money unless sufficient funds are held on behalf of the specific client or third party to make the payment. This rule prevents teaming and lading, using one client's money to pay another client's obligations. Example, if client A has £500 in the client account, the firm cannot pay a £600 disbursement for client A, even if the general client account holds £1 million from other clients. The £100 shortfall would be funded by other clients' money, constituting a serious breach. Written notification of costs, Rule 4.3. Crucially, firms must provide written notification of costs, typically in the form of a bill of costs, to the client or paying party before transferring client money to settle costs or disbursements. Transparency. This requirement ensures that clients are fully informed about how much of their money is being used and for what purpose before the withdrawal occurs. It prevents firms from unilaterally applying client funds without the client's knowledge. Mechanism. The notification can be a formal invoice or another written notification, e.g. a completion statement in conveyancing. In practice, this means that no transfer for fees should occur until the bill has been issued and clients have had the opportunity to understand and, where appropriate, query the charges. Disbursements. The SRA has clarified that firms can reimburse themselves for paid disbursements, expenses already incurred by the firm from the business account, provided a bill or notification has been sent. For unpaid professional disbursements, e.g. counsel's fees, the money is client money and can be paid directly to the counsel from the client account without a prior bill to the client, provided it is for the purpose of the retainer. Authorization and supervision. Payments out of a client account must also be appropriately authorized and supervised. Firms must ensure that withdrawal instructions are reviewed and approved by qualified personnel, often senior fee earners or compliance officers, COFADs, to safeguard against errors and misuse. This is a key internal control tested during SRA inspections. A very narrow exception exists under Rule 5.1c of the Accounts Rules for withdrawal of very small residual balances, such as client account balances of £500 or less, paid to a nominated charity, provided certain conditions are met.
Even this limited exception is tightly controlled and must comply with regulatory guidance.
AML, client money and regulatory risk controls. While the accounts rules and anti-money laundering regime are separate regulatory instruments, they intersect in practice because misuse of client accounts can facilitate financial crime. The SRA's guidance on improper client account use explicitly notes that allowing a client account to operate as a banking facility increases the risk of money laundering and undermines professional independence. The 2026 AML Framework. The AML framework applies to firms that provide services falling within the Money Laundering Regulations 2017, as amended, including transactional legal services, conveyancing, M&A, trust creation. Firms are expected to carry out practice-wide risk assessments, identifying risks inherent to their specific client base and services. Conduct client and matter risk assessments, assessing risk at the individual file level. Perform customer due diligence, CDD, verifying the identity of clients and beneficial owners. Monitor transactions, identifying suspicious activity, such as funds coming from unexpected sources or requests to return funds to a different account. Red flags in client accounting. Although a breach of an accounts rule does not require evidence of actual money laundering, regulatory guidance recognizes that weak controls over client accounts, such as inadequate reconciliation, improper transfers between client ledgers, or failure to verify the source of funds, create vulnerabilities that criminals can exploit. Source of funds, SOF. Legal cashiers and fee earners must verify the source of funds before accepting them into the client account. Accepting large sums without SOF evidence is a primary trigger for SRA fines. Rapid movement of funds. Money entering and leaving the account quickly without clear legal work being done is a classic money laundering typology, layering. Third-party payments. Requests to pay proceeds to a third party, for example, please pay my sale proceeds to my brother, are high risk and often prohibited under Rule 3.3 without robust justification and due diligence. Firms must therefore design their AML policies and client account controls to work together, ensuring that suspicious transactions are identified and that regulatory obligations are met in both regimes. The SRA's AML guidance emphasizes proactive strategies for identifying and mitigating risk, including maintaining up-to-date risk profiles for clients and matters and ensuring staff understand and implement AML measures effectively. Accountancy records reconciliation and reporting. Accurate and detailed record-keeping is at the center of compliance with the accounts rules. Firms must maintain separate client ledgers for each matter, record all receipts and payments, and ensure that client money is traceable from receipt to disbursement or return. Double-entry bookkeeping. The SRA requires accounting systems to be based on double-entry bookkeeping principles. Every transaction must be recorded twice, once as a debit, DR, and once as a credit, CR. Asset accounts, e.g. bank, debit to increase, credit to decrease. Liability accounts, e.g. client ledger, credit to increase, firm owes client, debit to decrease, firm pays client. Income accounts, e.g. profit costs, credit to increase. Expense accounts, debit to increase. Key SQE scenario. Billing a client. When a firm issues a bill for £1,000 plus £200 VAT, 1. Debit client ledger business section £1,200, asset client now owes the firm. 2. Credit profit costs ledger £1,000, income firm has earned revenue. 3. Credit HMRC/VAT ledger £200, liability firm owes VAT to HMRC. Key SQE scenario, abatement, reducing a bill. If the bill is reduced by £100 plus £20 VAT, 1. Debit profit costs ledger £100, reducing income. 2. Debit HMRC/VAT ledger £20, reducing VAT liability. 3. Credit client ledger business section £120, reducing the amount the client owes. It's worth noting that if the disbursement being abated was a VATable service, the VAT ledger must also be debited.
Three-way reconciliation, Rule 8.3. One of the most important compliance processes is client account reconciliation.
Under Rule 8.3, firms must obtain bank statements for all client accounts and reconcile them with the firm's internal records at least every 5 weeks. This is not just a comparison of the bank statement to the cash book, it is a three-way reconciliation that must agree. 1. Bank statement balance, the figure on the bank statement adjusted for unpresented checks or lodgements. 2. Cash book balance, the running total in the firm's internal cash log. 3. Client ledger total, the sum of all individual client ledger balances. Formula: adjusted bank balance equals cash book balance equals total of client ledgers. Note that adjusted bank balance means the statement balance minus unpresented checks plus outstanding lodgements. This regular reconciliation ensures that discrepancies are identified quickly, errors are corrected, and client money is properly accounted for. Firms are expected to document reconciliations comprehensively, showing evidence of who prepared and reviewed the process signed off by the CFOA. A lack of reconciliation or recurrent unreconciled differences can be interpreted by the SRA as a failure to maintain adequate systems and controls, attracting regulatory action.
Accountants Reports, Rule 12. In addition to internal reconciliation, many firms are required to obtain an accountant's report at the end of each accounting period. Reporting accountants review client money controls, reconciliation practices, and compliance with the accounts rules. Exemptions: firms are exempt if they hold only legal aid money or if their average client balance is less than or equal to £10,000 and the maximum balance is less than or equal to £250,000 during the accounting period. Qualified reports: if a report is qualified due to serious or persistent breaches, the firm must deliver that report to the SRA. 2026 proposals. Following the Axiom Ints review, the SRA has proposed requiring all accountants' reports, qualified or not, to be submitted to the SRA to improve market oversight alongside an annual declaration of compliance. Residual balances and return of client money. A common area of compliance difficulty for firms involves residual client balances, amounts left in client accounts after a matter has concluded and fees, disbursements, and other liabilities have been satisfied. Under Rule 2.5 of the Accounts Rules, firms must return client money to the client or third party as soon as there is no longer a proper reason to hold it. The promptly requirement. The regulatory expectation is that residual balances should not sit indefinitely in client accounts once the firm has completed its work. Just in case is not a valid reason to retain funds. Firms should maintain procedures for determining when residual money should be returned, for example, file closure checklists, and should take reasonable steps to trace clients or other payees if contact details are unavailable. Paying to charity, Rule 5.1c. Where clients cannot be traced, the rules provide a mechanism to clear these balances to charity. Balances of £500 or less, firms may withdraw these funds and pay them to a charity of their choice without SRA authorization, provided they have taken reasonable steps to trace the client and recorded those steps. Balances over £500, firms must apply to the SRA for prior written authorization to withdraw the funds. The SRA will require evidence of extensive tracing efforts, for example, use of tracing agents, DWP searches, before granting permission. Firms must keep a central register of all such withdrawals, detailing the client name, amount, steps taken to trace, and the charity receipt. These provisions balance the principle of returning client funds with pragmatic approaches to uncontrollable situations.
Enforcement, sanctions and professional standards. Compliance with the accounts rules is not purely administrative, it is a professional duty rooted in the SRA's broader regulatory objectives, which include protecting consumers, upholding the rule of law, and maintaining confidence in the profession. Where firms breach the accounts rules, the SRA may take enforcement action under its disciplinary powers. The Enforcement Toolkit 2026. The SRA's enforcement powers have been significantly expanded by the Economic Crime and Corporate Transparency Act 2023. Unlimited fines. For breaches related to economic crime, which includes many serious accounts rules failures involving AML, the SRA can now impose unlimited fines without referring the matter to the Solicitor's Disciplinary Tribunal. Increased cap. For other breaches, the SRA's internal fining cap for traditional firms has been raised to £25,000. Fixed penalties. A fixed penalty scheme has been introduced for lower-level administrative breaches, such as failure to submit diversity data or late delivery of accountants' reports. Sanctions and severity.
Enforcement outcomes vary across firms and individuals, but common sanctions include formal warnings, financial penalties, conditions on practice, suspension, or even strike-off in serious cases involving client money misuse or persistent non-compliance. Dishonesty. As established in SRA against James and SRA against Beckwith, a finding of dishonesty regarding client money, e.g. using client funds to prop up the firm's cash flow, almost invariably leads to strike-off. Personal mitigation, stress, health is rarely sufficient to avoid this outcome in dishonesty cases. Banking facility. Breaches of Rule 3.3 are treated as strict liability offences. The SRA does not need to prove money laundering occurred. The risk created by the facility is sufficient for severe sanction. Duty to correct. Rule 6.1. When breaches are discovered, firms are expected to correct them promptly, returning improperly withheld or withdrawn money to client accounts as soon as possible. Under Rule 6.1, any shortfall must be replaced immediately, typically by transferring funds from the business account. Failure to rectify breaches immediately upon discovery is an aggravating factor that can escalate a negligent error into a disciplinary matter. Integrating compliance for protection and public trust. The SRA accounts rules represent a comprehensive regulatory regime that is central to the ethical and operational conduct of solicitors and firms in England and Wales. By establishing detailed obligations on handling client money, segregation requirements, reconciliation procedures, and withdrawal conditions, the regulatory framework ensures that client funds are protected, traceable, and only used for proper lawful purposes.
For practitioners and aspiring solicitors preparing for FLK2 assessments, mastery of these rules is critical. It requires understanding not only the technical requirements, but also how they tie to professional duties, enforcement narratives, and wider regulatory strategy. The post-Axion INS landscape of 2026 demands a higher level of vigilance than ever before. Compliance is not a static checklist, it is an ongoing, proactive commitment to safeguarding client interests and maintaining the integrity of the profession. As we've seen in this presentation, the SRA accounts rules are not a set of abstract technicalities you can learn once and forget. They are a core part of professional responsibility. Standards that safeguard client money, uphold public confidence, and define what it means to practice law ethically in England and Wales. Whether it's holding client funds, reconciling accounts every 5 weeks, understanding when and how money can be withdrawn, or integrating anti-money laundering controls into everyday practice, these obligations shape how solicitors operate at every stage of a matter. Understanding these rules doesn't just help you pass the FLK2 assessment, it prepares you for real accountability in practice, where the consequences of misunderstanding or misapplying them can extend well beyond poor marks. They can affect clients' lives, a firm's reputation, and, as illustrated, your own right to practice. If you found this video useful, practical, and thought-provoking, you're in the right place. In Dr. Yannis' channel, we explore key regulatory concepts in depth, linking professional standards with real-world application for aspiring solicitors and law professionals. Take some time to look around the channel for more content on regulatory frameworks, professional conduct, examination strategy, and the skills you need to succeed as a future legal practitioner. Thanks for watching, and I'll see you in the next lesson.